May I please, my lord? May I please, my lord? My lord, item 54 is very urgent. 4 times it has been distributed but could not reach. It may be taken before rising of a first hour.
We'll see that also.
My lord,
We'll see. Yes.
my lord. এটা urgent କାହିଁକି ନା unnecessary ତା ଦରମା deduct ହଉଛି ଜମା 2000 ପାଉଛି patient ଟା ଆଜ୍ଞା. I pray, my lord.
Yes.
My lord, item number 18, I pray short adjournment for removal of defects, my lord. 1 week time, I am ill. Item number 18, WPC 31007.
Dankana.
Yes, my lord.
Dipti Prasad Patel.
Dipti Prasad Patnaik,
Yes, my lord.
counsel appearing through virtual mode, virtual High Court Dankana, submits that will remove the defects as pointed out by the stamp reporters. How much time you want, sir?
1 week time, my lord.
1 week time. Put up this matter after all the defects are removed. Here.
My lord.
Lordship, one mention I had done the last week also, Lordships. The urgency is that the marriage of the sister is fixed for the 3rd of the January. This is a DV matter, Lordship. And tomorrow we have the last DV of this week. And then the next week, only 2 days are after that the court will close, Lordship.
Item
Lordship, on the same day I had filed the mention memo.
that's a TV matter, as you said.
Yes, Lordship. I am in jail for more than 13 years.
So whether that man is in custody for 7 years or more.
Yes, Lordship, he is in jail for more than 13 years.
What
More
is the
than
number?
13 years.
What is the number?
599 13. No, item number?
Lordship, IA number 3220.
No, don't say IA number. CRLA number, please.
CRL number?
CRL 49/14
Oh.
and 599/13.
That is the IA number. Yes, it will.
I'm obliged, Lordship. I'm deeply obliged.
Supplemental list, item number 1.
My lord, the conducting advocate Narendra Kumar Das, he is guilty. Last date also he was.
Narendra Kumar Das?
He's sick.
He is sick. So if he permitted, I can take up the case. Or time one he recovered one.
No, if you can argue and if you have been interested, there is nothing.
You have been interested by Mr. Das?
Yes, I have been interested.
Then you argue what is there.
My lord.
Can argue the matter if you are interested.
My lord, in this writ petition, the petitioner's Stithiban right has been recorded in a government khata. In final publication of RR, under this above background, the writ is filed. My lord, it is submitted that the case land stands recorded in name of Hajari Dehari in Sabir Khata 174/47, and from the Hajari Dehari, the petitioner has purchased the land through different interim vendors, and the land was recorded.
It seems that you have earlier,
status,
Mr. Counsel,
67.
Please hear.
You have earlier approached this court twice. So one is WPC number 1608 of 2014, and the other is 18399 of 2021. So where is the judgment?
Miller, this judgment is it is a covered matter, and the judgment is at page 81.
Which order is in? Which order has been challenged in this writ? Which order?
Rent case order. Page
no, which one? Page? No.
16.
Annexure
5.
Annexure 5.
The petitioner filed objection petition before the settlement authorities to record the land in Gharabari status, and accordingly, as per order of the ESO at page 71, हाल प्लट 11/51/2294 एकड़ 0182 खाता 121 रु खारज करी विभू प्रसाद गंतायत पिता गौरचरण गंतायत जाति ब्राह्मण आईआरसी विलेज नाम स्थितिवान रेकर्ड करी जमी जमा कसट मते पूरण कर order was passed to record the land in his favor but surprisingly in the final publication of parwa the land is recorded in government khata by page 40 annexure 1 page 15
On which day? This order has been passed on?
this
The order that you read, that was passed on?
it was passed on
29/11/2012.
Miller
29/11/2012.
Miller
Is it?
Miller
And when the other ROR has been published?
the ROR is published during 2013
Where is that?
the ROR is at page
No.
17
Where is the direction for publication of that?
and I have enclosed the net copy of the ROR page 17
No, that
It is-
must have been done on the basis of a direction. Where is that?
no notice is served on the petitioner and the petitioner does not know how it is recorded in government khata. When the order was passed to record it in Stitivan status as per the Wheeler case number 9198 at page 67 in Stitivan status and accordingly in the rent case the order was passed to record the suit land in favor of the petitioner but it is very surprisingly it has been recorded in a government khata.
Where it has been recorded as government khata? Who page?
At page
Certified copy of the ROR, jota khali seta dekho.
page 70, page
17.
14,
14,
page
14.
Page 14.
14.
14 and 15. 11/91/2294 plot.
এই ଯୋଉ ଆବାଦ ଯୋଗ୍ୟ ଅନାବାଦ ଲେଖା ହେଇଛି ସେଗୁଡା କହୁଛି।
Since it is a lease land, they have recorded it in government khata. But once this
এটা
lease
କେବେ
is duly sanctioned in WL case, and accordingly, the
30th
Wheeler
December
quota
2014
and
only
the Bhagavani quota was issued in favor of the petitioner. And in similar case, my lord, I have cited this decision. In the similar case, Devasri Mahapatra has purchased the land from
Yes,
and accordingly, Honorable Division Bench have passed order to record the land in favor of the petitioner. At page 81. As per the decision of Narottam Pratha case.
Okay. The petitioner, Vibhu Prasad Gantaya, has filed this writ petition challenging the illegal and arbitrary final publication of ROR of Village Good Patna, wherein the suit schedule land has been recorded in Avad Yogya Anavadi Khata, even though it is supported by the records and titles of the documents along with the order stated 29/11/2012 passed in rent objection case number 1225 of 2012 that the suit schedule land be recorded in the name of the petitioner in Stitivan status and Gharbadi Kisam. The Learned Counsel for the petitioner drew the attention of this court to Annexure 5, which is the order dated 29/11/2012, passed by the ASO in rent objection case number 1225 of 2012. The Land Council submits that the order clearly indicates that so far as the hall plot number so and so lekha hoiche na khata number so and so, it is to be recorded in the name of the petitioner in the Stitivan status. And accordingly, direction was issued to correct the land records is submitted that in spite of such a order passed under Annexure 5 in the Hall ROR, the same has been recorded as Avada Jugya Anavadi Kata, which is without jurisdiction and illegal, and therefore the same is liable to be set aside, and the authorities are bound to publish the phrase ROR in accordance with law. Issue notice on the question of admission, indicating therein that the matter shall be disposed of at the stage of admission. Land counsel for the state accepts notice for opposite parties number 1 to 5. Extra copies of the writ petition be served on the land counsel for the state. So far as private opposite parties number 6 to 9 are concerned, requisites for issuance of notice shall be filed within a week, and the matter be placed on such and such date. Counter affidavit need to be filed in the meantime. Yes.
Item 2.
This case, for convenience of both the parties, I propose, if your lordship, due to little bit of statutory defect, notification है old act रे 8/7/13 जो land acquisition act 1894, किंतु आमर ए न्यू एक्ट आसिला 19/12/13 रे पेज माय लॉर्ड पेज 24 annexure 1 dispute 8 रही टिके पेज 24 no 8/7/15 notification for construction of railway overbridge Nalco my lord transfer station to NTPC 2.5 kilometer किंतु न्यू एक्ट आसिला 19/12/13 रे but presently see the parameters to be considered by the collector section 26 27 28 29 and 30 एथिरे they will pass the separate award and government would guidelines theory question my lord how to prepare the market value and damages and compensation solution. If I pray, let it be remanded to the collector again, see, as per the notification 26 27 to 30 that total deal ହେଇଛି, so they will pass an award. And যেহেতु land is by lord acquired for the purpose of railway overbridge, 29 crores provided by the railway authorities. So they are saying unless the proposal is submitted by the district
Give a
administration,
copy to Mr. Naik, let him examine whether
separate award ହେଲେ so entire problem shall be solved. Just
ଏଇଟା କଣଟେ ଆପଣ ଦଉଛନ୍ତି କଣ?
notification ର copy.
ଯୋଉଟା କି just 2-3 ମାସ ଭିତରେ ଆସିଲା ସେଇଟା ଆମର notification ହେଇଥିଲା
hand over a copy, let him examine.
ଆଜ୍ଞା ହଁ next page ରେ ମାଇଲର ଅଛି next page ରେ ସେଇ ଯୋଉ 7/2/14 ରେ intervention ହଁ intervention ସେଇଟା comprehensive guidelines ଟା so ଏଇଟା ଅନୁସାରେ collector award କରିବ so entire problem shall be solved. ସେଥିରେ ସବୁ RR package, the manner of determination, everything is dealt with. ଏଇଥିପାଇଁ problem ଟା ମାନେ again and again
The petitioner petitioners file this writ petition with the following prayers. Quote from paragraph number 2, 3, and 4. The learned counsel for the petitioner has produced what is this notification? Notification of the government of Orissa Revenue and Disaster Management Department dated 7/12/2014, where the procedure for determination of compensation has been mentioned. It is the case of the petitioner that in the case in hand, the same has this notification has not been taken into account while determining the compensation amount, and the stop. The notification produced, taken on record, let a copy of the notification. এটা কোনো extra copy টা দিয়েছেন কি?
দুইটা দিয়েছি ম্যাম।
দুইটা কপি
এটা দুইটা দিয়েছেন।
নাই মোটা দিয়েছি।
তাহলে সেটা ওটা extra দিয়েছেন তাকে দিয়েছেন। তিনটা আপনি দিয়ে দিয়েছেন। A copy of the said notification has been handed over to the Land Council for the state. এটা হচ্ছে 7/2/2014 ଆପଣ determine କେମିତି କରିବେ କଣ କରିବେ ଏଟା procedure ସେ କହୁଛନ୍ତି ଏଟା follow ହେଇନି ଏଇ କେସରେ ଦେଖିବେ କଣ ହେଇଛି।
Well, I'll examine. May I also submit the acquisition pertains to the railway authorities. The learned DSGI is online. The copy may also
We are from pin number 1, 2, and 3, my lord.
Mr.
Sanjeev Swai.
Earlier, Mr. Swai is appearing. This time, we are appearing.
No, it's all
because
right.
he's,
Please take into account a notification has been produced before us
Yes.
that how this compensation is to be determined. The
my lord,
government
it
has
will
got-
helpful be for me if Mr. Mahanti will serve a copy to us. We will take the instruction also.
You will serve a copy.
Yes, yes.
A copy of the notice notification be served on Mr. P.K. Paril, Deputy Solicitor General, along with Achita. Acha, okay.
S.K.Sahoo, yes.
All right. Out of this matter, let it come after Xmas holiday.
Item 3.
But 3 same.
3 also same, my.
Same
All right.
Same, yes.
Item 4.
Keep of the email appeal to the opposite party number 1, 2, 3. Our state okay.
May I
Which है? First case में से pass.
जहाँ ना से देशन जो ने दे रहे हैं. Yes.
On 14/11, my lord, my friend appeared for the opposite party, taken notice, and this is a matter regarding the exercise of option for BRS from the BSNL. About 70,000 to 80,000 employees were a surplus. So, Government of India, the BSNL floated a scheme on Annexure 1. I'll kindly turn to page 25.
Who is for the
Mr. He is appearing for the
opposite party.
so
I should not notice, and
notice has been issued.
he has appeared in
Not
appeared and
admitted,
taken
my lord.
notice.
On being instruction, I enter appearance.
So
Not
what
at
is the
admitted.
prayer in this case?
Prior, my lord, the Central Administrative Tribunal has directed the BSNL to take back the petitioner into service, opposite party into service. After he has submitted the BRS, then withdrawn, then again applied, and again after some days he said want to withdraw the written order. The scheme is, my lord, page and to find the
Please come to paragraph number 9 at page 66.
my lord. My lord.
Please, Mr. Patnaik, please, you can use this mode. Welcome.
My lord.
Paragraph number 9.
Before that, the Honorable Tribunal quoted the procedure rule 7 of the scheme. That I may place that because that is interpretation of that is the deciding factor.
Mic tab adjust kar diya.
That page 66 of
You want to place that
Procedure.
Oh, please place.
The option once exercised under the scheme shall be final, and decision of the competent authority shall be binding on the concerned employees, provided that employees will be allowed to withdraw the option only once and at any time till the closing of the date of the option. Provide further that the request for withdrawal of the option shall be submitted online along with a signed copy of writing. The authority for acceptance option under the scheme shall be the competent authority defined on clause 3C. Further, clause 8(7) of the scheme provides the competent authority shall have the absolute discretion either to accept or reject the request for an employee seeking voluntary retirement under the scheme without assigning any reason. In case of any doubt of ambiguity over the meaning and interpretation of any of the terms of the scheme, decision of the option shall be final. Then para 8. From the aforesaid provision of the scheme, it is clear that certain conditions were provided and also a specific form in which application option for VRS has to be made and the way it was to be submitted under the scheme was to be made. Further, it is also the seen that just applying for withdrawing a through ERP portal doesn't make it final. The acceptance of it was also conditional. Applicant has applied for VRS on 8/11/19, withdrawn it on the same day, and then again reapplied on VRS on the same day. All the said actions were done well before the stipulated closing date of the scheme. As the scheme, request for withdrawal of the option shall be submitted online along with signed copy of the writing, which is applicant has not done. Which has
Applicant
has done.
done
No,
so.
it is not correct. This finding is not correct. I will show you. So it is seen that from the record that the applicant has not submitted the hard copy of option for withdrawal of the scheme, which is mandated as per the scheme. Therefore, the withdrawal is not withdrawn as per the scheme, and the second withdrawal, which is submitted on hard copy, is to be treated as only option for withdrawal submitted by the applicant. In this case, my lord, I will show, my lord.
What is it?
Please completed.
Sir.
Completed.
Sir. Second withdrawal shall be submitted, and the hard copy is to be treated as the only option for withdrawal submitted by the applicant. For it is seen from the scheme that just submission of option for withdrawal from PRS is not final. As per the clause 8(7), the competent authority has the final say on whether to accept or reject it. Therefore, when there is no withdrawal option submitted to hard copy, which is mandated as per the scheme at first instance, and she has categorically mentioned it is her representation that she wanted to withdraw the VRS scheme, it is incumbent upon the respondent to consider and act upon it. It is not the case that it could not be done since the competent authority had the discretion to accept or reject. The competent authority should have considered the case of the applicant since she had done it well within the stipulated period. Accordingly, we find the action of the respondent is not considered for option and representation for withdrawal, where is illegal and bad in law. Therefore, the impugned order dated 2/1/2020 and 31/2020, as far as the applicant is concerned, is first, respondents are directed to consider the case of the applicant for reinstatement in accordance with the rules and formalities and was pursued. So, my lord, that the tribunal held and actually incorrect. Why I say, my lord, I will turn to the 34.
No, these factual aspects are not disputed. That he applied for it to avail his scheme, and then again on the very same day, right? So he filed withdrawal application.
Then again applied.
Again?
Then again applied. That's on the same day.
Huh.
So the scheme says you cannot withdraw after filing second application, that cannot be withdrawn. First applied on 8/11, after some 2 to 3 hours, again withdrawn it, then again applied. So the scheme says clearly, second time you cannot withdraw after applying.
No, scheme says about withdrawal only once. During till the closing period.
So first applied on the 8/11 applied first day. Then same day we do it.
So that means he was not interested for that.
Not interested. For again, what again applied. Now the question is whether first application 8/11, then same day again withdrawal, then second applied. So if you apply for second time, that cannot be withdrawn. That is 16. Now this procedural part is that you have to file an application of the written form along with withdrawal, which he has not done. They are not withdrawn. Adi computer withdraw करिनाथि. Second application पर 3 दिन पर देइछ. Scheme our Civil 7 specifically कहूची. You can only option once.
That means now his request for withdrawal is
not along with the withdrawal for computer apply withdraw करनाथि.
second बर्तन कौन second टा जो देले अपन तापर कौन action नेले
माने कल नबन computer नबन
अच्छा
अरे अपना नहीं गला से दिन withdraw करले पुनः उसरे apply कर देले second time second application करा से withdraw ही करी
Kintu, according to tribunal, the first withdrawal which has been made by the employee is not in accordance with the scheme.
No.
That is how it is not a withdrawal.
That is it. But it is the option, exercise is the option. So, jane computer apply kala.
ସେଥିରେ ଆପଣଙ୍କର ଅଛି ଯେ ଜଣେ ଅନଲାଇନ କରିବ ଏବଂ ହାର୍ଡ କପି ସାଇନ୍ଡ କପି ଦବ ତ ସେ ହାର୍ଡ କପି ଦେଇ ନାହିଁ ବୋଲି ଟ୍ରିବ୍ୟୁନାଲ କହୁଛନ୍ତି
କିନ୍ତୁ ଥରେ ଆପ୍ଲାଏ କଲା ଅନଲାଇନ ଆପ୍ଲାଏ କଲା ସେଇ ଦିନ ୱିଥଡ୍ର କଲା ତେଣୁ ସେଇ ଦିନ ଆଉଥରେ ଆପ୍ଲାଏ କରିଦେଲା ତେଣୁ ସେକେଣ୍ଡ ଥରେ ୱିଥଡ୍ର କଲା ତା ହାର୍ଡ କପି ଦେଇନି ଦେଇନି
ତାମାନେ ୱିଥଡ୍ରଲ୍ ଇଜ ନଟ୍ ଦେୟାର
ୱିଥଡ୍ର ନଟ୍ ଦେୟାର ନାଇଁ ସେ କହୁଛନ୍ତି ଆମ ହିସାବ କମ୍ପଲସରି ୱିଥଡ୍ର ହେଇଗଲା ଆପ୍ଲାଏ କଲା ଆପ୍ଲାଏ କଲା ତାପରେ ସେଇ ଦିନ ୱିଥଡ୍ର କଲା ଗୋଟେ ସବୁ ଆଉଥରେ ଆପ୍ଲାଏ କରିଦେଲା ସୋ ଇଟ୍ ଇଜ ଆଉଥରେ ଯୋଉ ହାର୍ଡ କୁ ଦବା କଥାଟା ନାହିଁ ଦରକାର ନାହିଁ ସେଠି ସେକେଣ୍ଡ ଆପ୍ଲିକେସନ କଲା ତାକୁ ଯୋଉ ୱିଥଡ୍ର କଲା ତା ବି କମ୍ପ୍ୟୁଟର କରିନି
No, second time you apply kala
ଆଜ୍ଞା
ତାକୁ ବି withdraw କରିବା
ନା ସେଟା ୱିଥଡ୍ର କରିନି କମ୍ପ୍ୟୁଟର ୱିଥଡ୍ର କରିନି ସେଥିପାଇଁ କହୁଛି
ତ ୱିଥଡ୍ର ହେଇପାରିବନି ଆପଣଙ୍କୁ
ହେଇପାରିବନି that is the scheme ତେଣୁ ସେ କହିଲେ provided the employee is allowed to withdraw the option only once at any time within closing date so ଥରେ withdraw କରି ସାରିଲା ପରେ ଥରେ apply କରିଦେଲା ପରେ ସେ second application
tribunal is also not telling about the second thing. Tribunal is telling about the first action of the employee. According to the first action of the employee, he discharged the option of VRS and that he withdrew, which is under the scheme. According to your scheme, an employee can withdraw only once. So accordingly, he withdrew it. But that withdrawal is not in accordance with the scheme.
Without adding a hard copy.
All right. So it is not according to scheme. Means that withdrawal is not withdrawal or withdrawal.
Tribunal କହୁଛନ୍ତି ଆମ ହିସାବରେ withdrawal ହେଲା scheme ରେ
କେମିତି ହବ ହାର୍ଡ କପି ପୁରା ଦେଲେ ନା ସେ
କମ୍ପ୍ୟୁଟର ଷ୍ଟାର୍ଟ ସବସିକ୍ୱେଣ୍ଟ ପ୍ରୋସିଜରାଲ ପାର୍ଟ
maybe
3 ଦିନ ଦେବା କଥା
all right so did you accept it
ଆଜ୍ଞା
did you accept
ସେଟା ସ୍କିମ୍ କ୍ଲୋଜ ହେଲା ମିଳିବ ନା ଆଉ ପିରିୟଡ଼ ଅଫ ସ୍କିମ୍ ଯାଉ ଥିଲା 3 ବାର ପର୍ଯ୍ୟନ୍ତ ସେ ପିରିୟଡ଼ ପରେ
ହଁ ଠିକ ଅଛି କ୍ଲୋଜିଂ ପିରିୟଡ଼ ପରେ ଆପଣ ଆକ୍ସନ ନେଲେ
ହଁ
ତାକୁ ଆକ୍ସେପ୍ଟ କରିଦେଲେ
ହଁ ଆକ୍ସେପ୍ଟ କରିଦେଲେ
ଆଚ୍ଛା
କହିଲେ ସେ ଭିଆରଏସ୍ ନେଇଗଲେ ପଇସା 23 ଲକ୍ଷ ନେଇଗଲେଣି ପେନସନ ନେଇଗଲେ ସବୁ ନେଇଗଲେଣି
ତାର ବର୍ତ୍ତମାନ ଗ୍ରିଭାନ୍ସ କଣ
ପଇସା ବି ନେଇଗଲେ
complete I will say
କହୁନାହାନ୍ତି କଣ
my lord your lordship kindly give a glance the counter and additional counter they
no have you accepted
no my lord there is no pleading regarding payment of
pleading don't go by pleading the amount will go to your account
they have credited the amount that's all that is lying in that account I have not withdrawn single pay my lord because I have
you have applied for VRS
my lord
that has been accepted by the authority
my lord no my that acceptance is under challenge my
you have been also paid with those amounts
so my lord I have only submitted thereafter I have not submitted any documents for grant of any pensionary benefits my lord after submission of application to cancel my VRS I remain there my lord I have never with contact thereafter after the tribunal my lord tribunal was refused to grant me any interim order but finally decided my case what my lord pointed out your lordship kindly gave a glass
order Mr. Patnaik very that order that it was been finally accepted and you have also paid his
where is that
annexure 6
annexure 6
35 page
36
36
competent authority. Sanjeevani Raha, so and so. कौन लिखिंदे आदरे?
Personal number etiki. Personal area text etiki. Option discharge.
Option submission date होची लेखा आइची. November 8 2019. हाँ तापरे अच्छा voluntary retired since with effect from 31/1/2010
end of the
as per terms and condition of so and so. All these so and so are clear from business angle. Necessary final order of so and so along with in respect of the executive knowledge shall accordingly be issued. Okay. Then what is that about that amount that has been paid to him?
Just
In my read petition, I have mentioned that about this person and dates.
Could read petition.
Sir, para 7 and para 9 of the read petition.
Para 9. Accepted the benefits funds of BRS 23 lakhs and terminal leave encashment funds. She received the pension funds. Oh, pension be received कर silent. Yes.
The main question is sir, the second
kindly give a glance Annex 7.
Kindly see the second apply kale second application dele se tar hard copy ଦେଇଛନ୍ତି
ସେ ଛାଡ଼ନ୍ତୁ ମ ସେ ତ ବର୍ତ୍ତମାନ ଆପଣ ତାକୁ ଆକ୍ସେପ୍ଟ କରିକି ତାଙ୍କ ସ୍କିମ୍ ପଇସା ଦେଇ ସାରିଲେଣି ନା and he has accepted ଏବଂ pension amount ମଧ୍ୟ ଆପଣ ରିସିଭ୍ କରିସାରିଲେଣି ବୋଲି ଲେଖୁଛନ୍ତି.
No, ma'am. I have not received. Okay. Your Lordship kindly give a glance Annex 7, ma'am.
This writ petition has been filed.
May Your Lordship only give
Mr. Counsel, notice has to be issued is for the coming.
You come, you file.
File your counsel.
File counter.
This writ petition has been filed by the petitioner challenging the order dated 25/4/2024 of the Central Administrative Tribunal, Cuttack Bench, Cuttack, in OA number 20 of 2020. It appears that the opposite party, Srimati Sanjeevani Raha, filed OA number 20 of 2020 before the Central Administrative Tribunal, challenging the action of the petitioners in accepting her PRS in spite of withdrawal of the applications in the time limit prescribed in the BSNL Voluntary Retirement Scheme 2019 with a further fair to quash the order dated 2/1/2020 and 31/2/2020 and to allow the petitioner to allow the opposite party to be reinstated in her former post and to continue until superannuation. The London Tribunal, after taking note of the contentions raised by the London Council for the respective parties and taking into account the section 7, it is clause 7 of the scheme. What is that? BSNL 2019 scheme has been pleased to hold that the action of the petitioners in not considering the option and representation for withdrawal of our VRS of the petitioner as illegal and bad in law, and accordingly quashed the orders dated 2/1/2020 and 31/2/2020 with a further direction to the petitioners to consider the case of the opposite party for reinstatement in accordance with rules and formalities and to pass consequential orders. Mr. Patnaik and senior advocate drew the attention of this court to paragraph number 9 of the writ petition, wherein it is mentioned that the opposite party accepted the benefits offered under the VRS, such as ex gratia for rupees 23 lakhs, as the figure, and terminal leave encashment of rupees 4,18,915. And she also received the pension from the Comptroller of Communication Accounts (CCA) on 29/2/2020 and GPF from CCA on 2/3/2020. Stop. The London Counsel for the opposite party, on the other hand, disputed the averments taken in paragraph number 9 of the writ petition. Issue notice on the question of admission, indicating therein that the matter shall be disposed of at the stage of admission. Since the opposite party has already entered appearance, you have received and received the copy of the writ petition. Let the counter affidavit be filed to the writ petition within period of 4 weeks. Matter be listed on such answers that. Yes.
Interim order.
Interim order for stay of the
IA
there shall be stay of operation of the order of this one so until further orders. Yes.
तो सेटा देखला बेलକୁ मिस्टर पटनायक देखिबे आपण जो ऑर्डर टा इश्यू करले दैट वाज ए कंडीशनल ऑर्डर
माइल
सब्जेक्ट टू रिजल्ट ऑफ ओए देखिबे तो
and 107 माइल
I am aware of that.
Yeah.
Item 5.
Urgent patriot copy.
Yes.
Which lost. So, the land of the petitioner was acquired by the government of Odisha for establishment of private industrial law.
Your representation is
3 series lawsuit.
but that is dated 4/3/21 and one is 5/12/2022. Have you not received any communication from the authority? All right, this both the annexures have been addressed. One is to the which one you want to dispose of? Which authority is competent?
22. That is pending before the collector.
Okay. The second is 5/12/2022 jota to collect on address AG, है that is to be disposed of and
OP1
P1 तीन मास जो हमको दिया जाए तो देखिए. Yes.
Item 6.
Their matters will assure in disposal 12/12 minus.
What is that similar?
repetition
Land acquired and then no notice.
land acquisition
If you want.
next one please. Legally married wife. Okay. Different. Item 6.
case number so and so ଅଛି ଏଟା ଆପଣଙ୍କର ସେଇ ground ରେ dismiss ହେଇଯାଇଥିଲା
ଏଠି LMS କେସ୍ ହେଇଛି ଏଟା CMA 10423 323 2004 ସେଇ LMS କେସ୍ ଏଠି ଆପଣ annexure 1 ଦେଇଛନ୍ତି ଯେ
ସେଟା ହଉଥିଲା 351 of 2004 but ground is same ଦେଖିକିନି କଣ ଚେଞ୍ଜ କରିବା ସେତିକି କରିଦେବେ ଆଦେରେ କଣ ଚେଞ୍ଜ ହବା କରିବା କରିଦେଲେନି ସେ
କେସ୍ ନମ୍ବର ଆଉ ଏଇଟା
ଅର୍ଡର ଡେଟେଡ ବୁଝିପାରିଲେ ନା
pencil ରେ ଚେଞ୍ଜ
ଏଟା ଟିକେ ପେନସିଲ ରେ ଚେଞ୍ଜ କରିଦିଅନ୍ତୁ ପେନସିଲ ଗୋଟେ ଦେଇ ଦିଅନ୍ତୁ ମାଇନ୍ୟୁଟଲି ଦେଖିକି କରିବେ ଭୁଲଭାଲ ହେଇଯିବ
ନା ଗୁରାକ ବି ଚେଞ୍ଜ କରିଦିଅ
କୋଉଟା ନାଇଁ ନା ଚେଞ୍ଜ କରିବା ଦରକାର ଅର୍ଡରରେ ଆପଣଙ୍କର କେସ୍ ନମ୍ବର ଅର୍ଡର ଡେଟେଡ ସେଗୁଡା ବୋଧେ ଚେଞ୍ଜ ହବ ତେଣୁ ତାକୁ ଗୋଲ ବୁଲେଇ ଦେଇକିନି ଆପଣଙ୍କର ଏବେ ଯାହା ଚେଞ୍ଜ ହବ ତାକୁ ଲାଗି
item 7
Homestead land was acquired for the purpose of extraction of coal, but no compensation has been paid to the petitioner. Representations under Annexure 5 series is pending before the opposite party number 2.
collector Hon'Ble opposite party number 2 representation annexure 5 series है ना dispose of yes next
item 8
I'm a please your lordship. Item 8 your lordship. Similar matter was placed before the learned single judge yesterday, your lordship. Judge Vishnu to the registry, it has been listed before this honorable court. The matter is with regards to the inaction of the state authorities in settling the land in favor of the petitioners, your lordship, who are the successors of the refugees.
no you mean to say that it is a single judge matter
2 writ petitions of similar natures have been listed before the learned single judge, your lordship.
acha
Honorable single judge. Fine.
which bench
Justice K.R.
and orders have been also passed
It is the state has been directed to take instruction.
can you give the numbers
Yes, your lordship.
please give it
WPC number
WPC number
20529
20529 of
2023 year.
2023 and
Another one. Another one, your lordship.
all right which court that is
This one, your lordship, was listed before Justice K.R. Mahapatra yesterday as item number 3.
The London Council for the petitioner submit that similar prayer has been made in WPC number 20529 of 2023, which was listed before the Honorable Single Judge yesterday, and some orders have been passed. Let the registry take appropriate instruction as to whether this matter can be dealt by the division bench or the single bench, and accordingly the matter will be listed before the assigned bench. Yes.
I humbly apologize, your lordship. It is 2024.
अच्छा 2023 में 20529 এটা ঠিক আছে না
आज्ञा
out 2024 23 করে দিয়েছে 24 করে yes
item 9
Item 9, your lordship. The notice under Annexure 6 is under challenge, your lordship. Wherein the exercise of Section 3G under the NHAI Act is pending for final determination of the award. But at the same time, your lordship, if notice has been sent asking the present petitioner to vacate the premise in question, your lordship, which has been notified to be acquired for the extension of the Honorable ढेंकानाल Highway, Your Lordship.
After receipt of the notice, what you have done?
After receipt of the notice, while it is pending, Your Lordship, I have directly filed this writ petition for this honorable law.
Yes, would appear. No?
You should
Because, Your
appear
Lordship,
and file your
Objection. what-
objection to that notice, and that will be considered in accordance with law.
So, if my lord may peruse the notice, the said notice is not seeking for any show cause, Your Lordship.
No, you can. They have asked that you have done this, and that is why it is to be made punishable, and it is mentioned that you are hereby required to remove such unauthorized occupation within 7 days. That period has long since elapsed,
Yes, Your Lordship.
right?
Hmm.
So, and you see, the next line is very important. You may make representation
Yes.
within 3 days
Hmm.
from the date on which the notice is served to କାହାକୁ ସର୍ଭ କରିବ ତାକୁ ମଧ୍ୟ ଲେଖା ହେଇଛି ଏବଂ ଲେଖା ହେଇଛି further that such representation if made shall be heard on
Yes.
such and such date at so and so. Everything is there mentioned there. So without filing any representation before the appropriate authority, you have come to this court.
My humble submission to that effect, Your Lordship, the authority who has sent me this notice is
Whatever.
also a party in the arbitration.
You challenge it.
Challenge. You can
You can
take it to the notice.
Ah,
Whatever you want to say, why didn't you? And we do not know that what is the present position.
yes.
The
Because
present
that date has been long since over. So they might have taken steps in the meantime on the
as per
basis
my-
of the notice.
as
You
per
might
my
have been
instruction-
removed. Who knows?
As per my instruction, Your Lordship, no criminal case as of yet has been initiated
No,
against
we
the
can't.
petitioner.
Criminal case ଅଲଗା କଥା.
But
ଏଇଟା ଆପଣଙ୍କୁ
Eviction ଟା ତ
ହଁ.
ଅଛି ନା.
But with objection, Your Lordship, the petitioner has vacated the place.
you have
His-
already
Already are there.
Then?
His petrol pump is still lying on the
That is it.
that part of that parcel of land. Your Lordship.
ଦେଖନ୍ତୁ, this writ petition has been filed by the
I am
petition,
appearing for NHI.
petitioner Pradyumna Kumar Naik with a prayer to
Question is
quash the notice dated 3/10/2024 issued by opposite party number 1 by Danishar 6 with a further prayer to restrict the opposite party from taking any coercive steps till the adjudication of the arbitration proceeding. On perusal of the notice under Annexure 6, which is dated 3/10/2024, it appears that the project director NHAI PIU Denkana, kete number opposite party?
Opposite party, Your Lordship.
Project director.
Project director, opposite
2.
party number 2.
Opposite party number 2. On the basis of periodical inspection of the highway land, was satisfied that there has been unauthorized occupation and the petitioner has been issued notice to remove such unauthorized occupation within 7 days from the date of service of the notice. Stop. It is further mentioned in the said notice that he can make a representation within 3 days from the date on which the notice has been served on him to the opposite party number project director opposite party number 2, and such representation shall be heard on 7/10/2024 at project implementation unit plot number so and so near Kalinga Eye Hospital so and so. It is the submission made by the land council for the petitioner that the authority who has issued the notice is not empowered to issue the notice. However, he submitted that no representation has been made by the petitioner within the stipulated period, and the petitioner has straightaway approached this court challenging the notice for removal of unauthorized occupation. During course of argument, the London Council for the National Highways Authority of India submitted that in the meantime, the petitioner has been removed from the unauthorized occupation, uh, and the notice has been acted upon. In view of such a state of affairs, after hearing the Land Council for the so, since the petitioner has not availed the remedy as was given to him under Annexure 6, we are not inclined to entertain this writ petition, which is accordingly dismissed. Yes, next.
My lord, my name may be.
Yes,
Lord, well, liberty may be granted to at least file my reply.
They
They may consider it, your lordship. I do not have any grievance.
I will representation file we give.
At liberty, may at least.
No, you are given liberty. You see, thereafter steps have been taken.
This matter may be put up on 13/1.
On the very day that the other case.
तो correction कर दो तो you put a item number कितना कितना 6 रे সেটা কোন ডিসপোজ অফ হয়ে গেছিল আচ্ছা সেটা ডিসপোজ অফ হয়ে যেত যেটা করেকশন করে রাখা করেকশন করে দিতে বাকি নাটা চেঞ্জ হোক বাকি তো করেকশন তো ডিসপোজ অফ করে the same date রে appear variable price to date like this yeah correction over next
Item 10.
Item number 10, I pray for a passover, my lord.
Matter was yesterday posted, and today we are filing the affidavit. I saw the copy of the affidavit also.
Yes. What is this matter?
My lord, here the guarantor has paid the entire loan amount.
Document. Releasing of the document.
Not a NOC. Still, title is they are not releasing.
So you go through the affidavit, which has.
Lord, I have gone through it.
Yes.
At para 4 and 5 of the affidavit, they have stated that, ma'am.
Take the instruction from your client whether he is ready and willing to accept whatever has been stated or not. Don't take it on your own. You just received it without any intimation, without any information. Don't make a submission. Go through affidavit, let your client go through it. They have given some suggestion, or whatever it may be. So, what can
To
be
execute
done?
and indemnify bond.
The London Council, Mr. C.DASH, the London Council appearing for the bank, has filed an affidavit as per the order dated 17/12/2024. Copy of the same has been served on the London Council for the petitioner who seeks some time to obtain necessary instruction from the petitioner. Put up this matter, give a date. Yes, no.
Obliged.
Item 11.
The Odisha government land settlement matter, my lord. Repression is pending, my lord. Similar order may be passed, my lord.
Change.
Again, got this.
Annexure number.
Again.
Up to
Item 12.
I may be excused, my lord. In connection with item number 10, the branch manager is also present.
Acha, the branch manager, please, not.
They do.
Kali mention is like this.
Kali we hit the as they did
not. Not the present will.
Please.
Item 12.
My lords, item number 12 is a covered matter, my lords. I'm giving the copy. I have corrected.
LAPS.
Yes.
21, 28, 8.
Covered matter.
Next.
Item 13.
Item 13, may I please, my lords? My lords,
Just please.
my lord. My lord, the present petitioner is a president of DCDRC Cuttack, my lord. My lord, this is a matter relating to revised scale of pay. My lord, although my lord has recently disposed of another application with similar prayer, my lord. My lord, in this case, my lord, I want to make further submission, my lord. My lord, the present petitioner was a selection grade, my lord. He was retired as a selection grade, my lord. And the rule says, Rule 4, if may I draw my lord's attention to my running page number 20, my lord. If my lord is on Rule 4.
Just a minute. Let us see that what order you are saying.
Order those.
Similar matters have been disposed of.
Similar matter has been disposed of by this order, my lord.
By this court.
By this court.
Where is that?
Copy data ditch.
The
Where
representation
annexure 5
was
was to be
pending
considered,
before
madam.
the representation was pending for the Principal Secretary, Food Supplies and Consumer Welfare Department. That has to be considered.
My lord, my prayer is also covered by that, my lord. But one observation may I make that, my lord.
Representation here is also
Annexure 5 and which is pending before, my lord, opposite party number 2.
Principal Secretary.
No, my lord, not Principal Secretary here, my lord. It is Deputy Secretary, my lord.
Just a minute.
OP2.
OP2.
5 pending ଅଛି କାହାକୁ?
OP2
Deputy Secretary ମାନେ opposite party number 2.
ସେଟା same ଅଛି. But my lord, Rule 4.
It change ହବ. ଏଇଟା Principal Secretary swans हो जाएगा रे. इसका नाम बाकी लोगों का Deputy पे देखी change करिए. Opposite party number 4. ଆଉ ସବୁ ସମାନ ତ?
ଆଉ ସବୁ ସମାନ, ଖାଲି ଗୋଟେ submission ମୁଁ କରୁଛି.
Yes.
My lord, may come to running page number 20, my lord. Rule 4 of my brief. My lord, here it has said that the salary of the president of the district commission shall be equal to that of account admissible
let
to
them consider.
Let them
no, my lord, my case cannot be considered, my lord, because it says about super time scale. And my lord, second one, it says below the rank of district judge, my lord.
Then how you are again giving it?
My lord,
you say that it is similar.
My lord,
how then you are saying that it is similar?
My lord,
case?
my case, I'm in the cadre of my lord.
Cadre of district judge.
Selection grade.
In selection grade.
Yes, my lord.
And the earlier case was he was in
super time.
Yes.
My lord, rule says that below district judge cadre.
Filed a representation before a particular authority.
My lord.
You are expecting that the authority can deal with that matter.
My lord.
So we are asking the authority to dispose it of.
My lord.
That's all.
My lord. And my lord, one more submission, my lord. There it was 3 months, and the petitioner is going to superannuate on 16/1/2025, my lord.
Give them some time. They have so many wars to be done. All right, next.
I'm grateful, my lord.
Item 13.
Just take liberty, ma'am. May I just take liberty? Subjective process permits, my lord. That item number 10, my lord.
10.
Lord, I'm sorry, my lord. I was on my legs in some other court. Lord, I have received the affidavit. I have taken instruction from my client yesterday because there was a discussion.
Taken up next week. What is there?
I did not know the date when your lordship is fixing that.
Taken up
Next week, my lord.
Yes.
Item 14.
Wait, please, Millets. Millets, I beg to appear virtually, Millets. Millets, here, a proceeding under Section 14 of the SARFAESI Act was filed by me, I am the bank, against the borrower. Your lordships are aware of the position of law with respect to Section 14, which says that a Section 14 power is only a ministerial act. It does not involve any adjudicatory process. Plus, I have those.
What they have done?
Plus, what has happened? Plus, also under Section 14, it is contemplated that no notice shall be given to a borrower. When Section 14 was filed, the borrower suo motu on its own appeared, filed an application saying that please serve me a copy of the petition that you have filed under Section 14. And despite the fact that they don't have a right of hearing in a section 14 proceedings, I objected to that. I also brought to the honorable CJM's notice that the judgments of this honorable court, the judgments of Supreme Court repeatedly saying that there is no adjudicatory process involved and the magistrate should not brook any delay. That's the language of the honorable Supreme Court. Despite that, it has been directed that I will serve a copy.
That is the reason why you want this proceeding to be disposed of in a time-bound manner.
My lords, because that is the scheme of the statute, and your lordships, because it is a ministerial act, therefore, Millards, a 30 days time span is given for disposal of
No, you have filed the bank miss case and these opposite parties, all the opposite parties have entered appearance.
Yeah, they suo moto, no notice was issued. They appeared and they filed a petition.
No, when you have made them opposite party, they are bound to appear. So, they whether suo moto or on being noticed, then you have filed a case and made them opposite party.
Here, in this writ petition.
Yes, in this writ petition, they're a party, Millards, because they were party before the lower court.
Without hearing them, how do you propose that we can dispose it at this stage, or was for notice has to be issued, or at best we can say that your prayer number 2, it is to be allowed, and we can fix a time limit for disposal of that bank miss case.
Yes, Millards, but the impugned order has to go, Millards. The impugned order directs me to serve.
No, if you want the impugned order to go, that means you have made parties.
Has to be. It is up to you.
My only request, Millards, is that your lordship will fix a short returnable date. Considering the fact that, Millards, this is no adjudicated process involved.
The petition has been filed by the so-and-so with following prayer. So-and-so. The Land Counsel for the petitioner drew the attention of this court to order dated 29/10/2024, passed in miss case number 4 of 2024 by the CJM cum Assistant Session Judge Qatar, and submitted that in view of the decision of the Honorable Supreme Court in the case of so and so.
Yes, Millards. If your lordship, I'll give you the check. Yes, Millards. It is all referred to in my writ petition, Millards.
Which page?
Your lordship will see page 11.
Page
11, 13, Millards, there are several judgments cited.
In view of the decision of the Honorable Court, so and so, Bombay High Court.
Para 6, 7 and 8 re likha hai ji.
Acha, para 7 re likha hai ji, 8 re likha hai ji.
6, 7, 8.
That time is the while disposing of the application under section 14 of the SARFAESI Act, the magistrate has no element of quasi-judicial function or involvement of adjudication, and it is a purely ministerial in nature. And time is the essence, and it cannot prove delay once all the requirements under section 14 of the SARFAESI Act are complied with by the secured creditor. And it is the duty cast upon the magistrate to assist the secured creditor in obtaining the possession as well as the documents related to the secured assets. After like the issue notice on the question of admission, indicating therein that the matter shall be disposed of at the stage of admission. Requisites for issuance of notice to the private opposite parties number 1 to 4 shall be filed within a period of 1 week, and matter be listed so and so. Counter-affidavit, if any, will filed in the meantime. Yes, next.
Millards, only one request, Millards, let that order of impugned order be stayed, Millards, because it directs us to supply a copy. So, Millards, let that be stayed, Millards.
It is not likely to be disposed of as soon as possible.
Yes, Millards, therefore, Millards, the order is completely illegal.
If on the direction of the court you pass on a copy of the order also, how does it affect? Because ultimately it is the essence of the enactment we have to see. Section 14(1) says no adjudicated procedure. So you can pass on.
But the order at page 169
doesn't make any difference.
Yes.
let's one more.
Item 15.
Yes, item number 15.
Let's just one more submission. Annexure 10 ta complete file.
Item number 15, yes.
Let's just one more request. Annexure 10 ta complete file.
Council, we have already passed the order. Item number 15. Yes.
I have a simple prayer, my lord. I filed a RP case before the RDC Cuttack, my lord. It is a 223 of 2024, Annexure 3. My lord, that may be directed to dispose of with a specific period, my lord. And on that period, my lord, the land compensation for Subarnarekha project, my lord, not to be disposed in any paper, neither in petitioner paper nor in opposite
And
party.
again, question will not be held up till RP case number so and so pending in the court of opposite party number 4.
RTC CD Cuttack.
This is revision case. Revision is pending.
My lord?
Revision is pending.
Pending, my lord.
So the parties have already entered appearance.
No, my lord.
Then
ସେମାନେ ଆସିନାହାନ୍ତି ତ ବାପା ମରିଗଲା ପରେ ଆମେ ତାଙ୍କର କପି
ଆମେ ଜାଣିନୁ you have filed this case. Salim Khan is the petitioner here. You have made some persons as opposite parties.
Prabhati and Rabindra Sethi,
right?
The son and wife of the recorded owner.
We are putting you a question that whether in this RP case notice has been issued to the pro forma opposite party and the opposite parties.
Well, perhaps I am not advocate.
Take instruction over. Unless if you say that that case is to be disposed of, we must ensure that yes, all the opposite parties have already entered appearance.
Perhaps not, my lord.
Don't take perhaps. With this Cuttack, you can take instruction. What is there? The after this writ petition has been filed by so with this prayer, when we put a question to the land council for the petitioner regarding the status of the RP case number 223 of 2024 pending before opposite party number 4, and whether notice has been made sufficient on the opposite party and pro forma opposite party, he seeks some time to obtain instruction from this matter. Give a date. Yes.
Item 16.
That you
can see the date in the evening hours. He has to see the diary and the not in all cases.
In item 16, my lord, I am seeking a passover, my lord.
Amendment and objection. Who has filed this amendment application?
I had filed. Petitioner had filed the amendment.
You have served a copy on the council for the Punjab National Bank.
Yes, my lord. Copy has been served.
So any objection to the amendment?
In this case, I have already filed my objection. As specifically, we have not awarded the
additional was filed.
I have filed a counter affidavit to that effect.
Additional.
My your lordship, kindly see the last date order, ma'am. Where the
a copy of the additional affidavit to be handed over to the land and council
yes.
for the petitioner.
Yes.
You have given it.
Yes.
Already I have served.
Okay. So what do you want now?
My lord, today the argument must be done, and that has to be done by my senior, my lord. That's why I'm seeking
Passover.
Passover.
All right.
I'm seeking Passover.
Item 17.
Yes, with the council. Second copy not filed. Yes, sir, not made. Time the 2 weeks time to file the second copy of the writ petition. Failing which the writ petition shall stand dismissed without further reference to the bench. Yes.
Item 19.
Ganesh Prasad Samal. Same order, second copy. 2 weeks time granted for removal of swans. Yes, next.
Item 20.
20, Mr. Pratik Das. Not. Second copy not filed, same order, 2 weeks time granted.
Item 21.
21, which one?
21, my lord.
You are for the
Petition.
modification of order disposed of. Have you served a copy of this modification application on the Land Council for the Punjab National Bank? Who is the council? Soumendra Kumar Ghosh. All right, we are passing it over.
Item 22.
Mr. Kali Prasan,
Only pass over.
you are mentioning on whose behalf?
KP Misra, senior.
KP Misra, senior.
He is another court.
Yes, next.
Item 23.
That's item 23. There was a proposal from the state side to settle the dispute, my lords, and hence your lordship was directed to take instruction whether the state is taking steps for that, not my lords. Today morning, my lords, I have got instruction. My lords, it has been categorically stated the state is not in a position to settle the dispute. So the lordship may hear it on merit, my lords. I have got the instruction, my lords.
Pass on that instruction.
My lords, today I got it, so I just now.
What do you want to say?
Let's will file if your lordship permits me, I'll file an affidavit and then your lordship may take it up on merit.
My lord,
You want to file it with an affidavit?
Yes, my lord. That is what.
my lord, this is that case. Lordship may kindly recollect, my lord.
But it's all right. Now it is to be
They are
hardened.
not interested.
My lord, just one, two, couple of sentences, my lord. On all previous occasions, my lord, in fact, before this honorable bench and also prior to this honorable bench, before other benches also, I had almost concluded the argument. But time was sought for by the state on every occasion, on the ground that they want to settle the issue because it is a Khasman land. And
Sorry, that is not possible. You cannot compel a party.
no, the time was taken by the state not only on one occasion, on so many occasions on this ground itself. They want to settle the issue and also give
You
up.
are also enjoying the interim order.
Well, despite me being enjoying the interim order, the order has been violated for which the application for contempt is pending.
Well, I admit that, well, that is why I took
The
initiative so that.
Mr. Prabhu Prasanna Behral and an additional standing counsel submits that he has received instruction, written instruction
Yes, ma'am.
from the government that the matter cannot be settled, and he wants to file the same with an affidavit giving copy to the Land and Council for the petitioner. Mr. S.S. Das, Land Senior Advocate, is present. Please this matter. Date the second week of January 2020.
Madam, may I pray one short prayer in space to 7th of January, madam.
আচ্ছা 7th সেদিন এখন ভালো দিনও আছে না
The interim order to continue, madam.
on 2025 interim order to continue. Yes.
Obliged.
Item 24.
It has no with this content.
Item 24.
Yes, item 24, Mr. Mahanti. Next.
Item 25.
Mr. Patnaik.
Well, the item 24, Mr. Mahant is requested to pass for adjournment because of his ailment. Has requested me.
Sure. This Union of India is there. And there are defects also. A counter affidavit has been filed here. All right, a mention is made on behalf of Mr. Dilip Kumar Mahanti for adjournment. Land Council for the state is present. There was no serious objection for the adjournment.
That is Union of India.
Union of India, which was Devi. Transfer is present. Put up this matter. Give a date out in the January.
Obliged.
Item 25.
So item 25, my lords, I have submitted that the file was missing. We have reconstituted the file. I have taken consent from my learned senior. Lordship may kindly take it up after vacation. Lords.
What do you say? A mention is made on behalf of the state. to take up this matter after ensuing Xmas holidays. Land Council for the petitioner has no serious objection to the same. Please this matter. Yes, next.
Item 26.
26 minutes, I am for the petitioner. I am for the auction purchase of mallards.
26 kindly pass over matter. Kindly pass over the matter.
You are
Honorable Guru Dada.
You are for whom, Mr. Counsel?
On behalf of Guru Dada.
Acha, Guru Datta.
Kindly pass over.
Pass over.
Item 27.
So
Yes,
items,
Mr. Sharma.
well, as item 27,
Two occasions, they took time on the plea that they will file the counter on behalf of the registry. OP number 1 has filed the counter affidavit, state government, and have filed a rejoinder to that.
Just a minute. Let us see the previous order. Run counsel for the state submits the counter affidavit on behalf of opposite party number 2. Opposite party number 2 ki?
Registry.
it's registrar of this one.
Is under preparation and the matter may be taken up after a week so that the copy of the counter affidavit of the opposite party number 2 shall be served on the land counsel for the petitioner.
Well, it's, I took instruction. It is on the process of vetting, Malad. So that is why it could not be filed within the vacation. I'll ensure that it is filed, Malad.
Upon prepare so
Malad, I'm sorry, Malad. I take the responsibility, Malad. I'll file within the fact. It has not been vetted.
Sharma, what is saying? Au 7-8 दिन समय दबा छुट्टी पूर्व आसु. The Learning Council for the state submits that the preparation of the counter affidavit on behalf of the opposite party number 2 is under process and the matter may be taken up after ensuing Xmas holidays. Mr. Bigyan Kumar Sharma, Land Counsel for the petitioner, has no serious objection to the prayer for adjournment. Please this matter. Second week,
Item 28.
Mr. Susmita Naik.
Petitioner has filed this writ application challenging the order dated 26/2/2023 passed by the opposite party number 3, the Deputy Commissioner of the Land, BMC, behind Annexure 9-9.
Just a minute. Mr. Behra, you are for the opposite party number 1 and 2.
My lords, for the state.
And Mr. Panda is for opposite party number 3.
My lords.
Niranjan Panda Bhariji. So, what is your prayer in this petition?
My prayer, my lord, that they have wrongly calculated the compensation amount without following the procedure of law, my lord. So they have wrongly calculated, and I have prayed that let them calculate properly and honestly.
According to you, you are entitled to get more amount.
Yes, my lord.
What is according to your assessment?
They have not given the solution, my lord, because my land.
आपणकर जदि हिसाब रे आपनकु कहउचंती 86,23,960 टंका आ पाइबा को हकदार आपण या तो व्हाट इज योर काउंटर एफिडेविट Mr. Behra?
Malas, that record was not there, Malas. The record was not there with us, Malas.
Record?
This record is not with the state, Malas. BMC to reply. The BMC has filed, Malas, but with the state, that record is not there. Malas.
No, land acquisition officer.
Yes, Malas. I verified it is filed, but it was not with us, so.
And thereafter, the rejoinder was also been filed.
Yes, Malas.
Petitioner to the counter affidavit.
Malas, I'll collect it and I'll get prepared, Malas.
The Land Council for the state submits 6 for an adjournment. Please this matter. 6 seconds. Yes. Land Council for the petitioner is present for yes.
Item number 29.
29, Mr. Praharaj.
The petitioner has filed this writ application challenging the inaction of the opposite party number 1 bank who has no deed certificate and not closing the accounts and returning the documents in spite of full and final payment of OTS amount. They are harassing the petitioners in spite of best effort and payment.
Just a minute. Your prayer is for a direction to the opposite party number 2
My lord,
to hand over the keys of the dwelling house situated over Schedule B land, documents, no due certificate of the mortgage properties, etc. Okay. Now, in the counter affidavit, what is the stand taken by the bank?
Paras, page 7, para,
Counter affidavit, draw.
my lord.
Counter affidavit filed by opposite party.
25th 7, 2024.
25th 7.
Objection, page 7.
My lord,
data
he's-
on 12 February.
My lord, he is confusing the issue. Actually, कौन है initially से schedule B पे कोई था ना. DRT रे, let me explain to the honorable court. You are mixing up the issue.
Submit.
Again,
First, I am petitioner.
ଆପଣଙ୍କ ଘର ଚାବି ଦରକାର
Sir, on the views of the debt actress,
ସେ କଣ ପାଇଁ ଦଉନାହାନ୍ତି ସେଟା ଶୁଣିବା ଦରକାର ନା ନାହିଁ
ଦେଇ ଦେଇଛନ୍ତି ସେଟା
ଦେଇଛନ୍ତି ଆଉ କଣ ଦରକାର
by order of this honorable court.
ଆଉ କଣ ଦରକାର
ଆଉ
କହୁନାହାନ୍ତି
କଣ no due certificate and property document.
ସବୁ ସାର୍ଟିଫିକେଟ କଣ
My
ପାଇଁ
lord.
ଦଉନାହାନ୍ତି ଶୁଣିବା ନା ନାହିଁ ପୁଣି
ଏଠି ଲେଖା ଅଛି
ତାଙ୍କୁ ଶୁଣିବା ସେ କଣ ପାଇଁ ଦଉନାହାନ୍ତି ନା yes
my lord, if your lordship will see page 30, what had happened, my lord, he had more than one property. 2 properties were there. Auction ta jota hela, he challenged before the DRT. At page 30, because he paid the entire dues amount, DRT recording it, my lord, disposed of the essay. At page 30, that order is there. Then he approached this honorable court. ସେଥିରେ ଆଜ୍ଞା କଣ ହେଇଥିଲା ଅକ୍ସନ ପରଚେଜର ଯିଏ ଗୋଟେ ପ୍ରପର୍ଟି ଟା ଯୋଉଟା ସକ୍ସେସଫୁଲ ହେଇଥିଲା ଯିଏ 25% ଦେଇଥିଲା he was also a party. ଆର ପ୍ରପର୍ଟି ଟା ଆଜ୍ଞା auction had failed. So in that background the DRT allowed it. Then we came before this honorable court. What the auction purchaser did, my lord, though we returned the entire monies to him which he had given, which I have filed in my counter, he has filed a civil suit before the subject valuer which has been admitted in paragraph 13 over the other property, Schedule A property. Schedule A property initial prayer nathila. Then he filed an amendment. Your lordship allowed it, and seeing the order of this honorable court that Schedule B property answer original prayer answer writ application has been allowed. Schedule A ta jitala se ପରେ ଆଣିଲେ on record as per the amendment allowed by your lordship. That I filed a supplementary affidavit saying that he has himself admitted 2 things. One, he has sold the Schedule A property to another person. Secondly, my lord, the auction purchaser has filed a civil suit before the subject balancer right title interest property the claim କରୁଛି where the bank and the loaner parties. That is why we are unable to give him ownership कि schedule A property ର ତାକୁ documents ଦେଇ ପାରୁ.
ତାଙ୍କୁ schedule A property ଟା ଦେଇ ସାରିଲେଣି
नहीं ଆଜ୍ଞା schedule B property ଟା
ବିଟା ଦେଇ
ଦେଇଛନ୍ତି pursuant to order of this honorable court.
schedule A property ପାଇଁ litigations are pending according
Civil court ରେ ଆଜ୍ଞା he has himself said civil suit is pending and he has sold that property also. So that is why bank is unable ଯୋଉଥିରେ ଆମେ ବି ପକ୍ଷୀ ଅଛୁ ସିଏ ବି ପକ୍ଷୀ ଅଛନ୍ତି. So
what is the status of that proceeding?
That is pending my lord before the civil court.
ମାନେ କୋଉ stage ରେ ଅଛି?
ସେମାନେ ଗୋଟେ order 7 11 petition file କରିଥିଲେ ଆଜ୍ଞା. What I have got instruction for rejection of claim କାରଣ auction purchaser ଯେହେତୁ DRT has agreed.
Who has filed that suit?
Auction purchaser ଆଜ୍ଞା. ଯୋଉଥିପାଇଁ schedule A property ଟାକୁ ଆଜ୍ଞା
schedule A property ର auction purchaser
ଆଜ୍ଞା ଦୁଇଟାରେ ଆଜ୍ଞା ଯେହେତୁ କେହି ନଥିଲେ ଆମେ ଦେଇଦେଲୁ pursuant to orders of this honorable court. ଆଉ ସେଇଟା ଆଜ୍ଞା 3ଟା ଆକାଉଣ୍ଟ ର ଗୋଟେ ଲକ୍ଷ୍ମୀ ଟ୍ରେଡିଂ ଥିଲା ଆଜ୍ଞା ପ୍ରୋପ୍ରାଇଟର. ସେଥିପାଇଁ ଆଜ୍ଞା ଆମେ no dues ବି ଦେଇପାରୁ. That is our only difficulty.
plaintiff ହଉଛନ୍ତି auction purchase.
ଯାହାଙ୍କୁ my lord directed
case number ଟା କୋଉଠି mention ହେଇଛି
ଆଜ୍ଞା ଆଜ୍ଞା
page 7 and mention ହେଇଛି.
my lord page 9 present.
Order objection ରେ ଦିଆହେଇଛି. No, your objection.
ଆରେ ଆମ ଆଡେ କୁହନ୍ତୁ ସିଆଡେ କାଇଁ ଅନଉଛନ୍ତି
ଆଜ୍ଞା paragraph 16 page 9 ଦେଖନ୍ତୁ
ସିଭିଲ ସୁଟ ର ନମ୍ବର ଟା କେତେ ଆପଣ ସିଆଡେ ଅନେଇକି
ସୁଟ ନମ୍ବର 1853 ବାଇ
କୋଉଠି ଲେଖିଛନ୍ତି
ସିଏ ଲେଖିଛନ୍ତି
ଆଜ୍ଞା ସିଏ ବି ଲେଖିଛନ୍ତି ମୁଁ ବି
para 16
କାଉଣ୍ଟର ପେଜ
para 97
16 ଆଚ୍ଛା CS number 1853 of
and there is no interim order passed by the civil court.
Pre-modern ନହେଲେ ଆଜ୍ଞା କଣ ହବ? That is subject matter of challenge.
And my responsible submission is that I am the petitioner in this case. My responsible submission is that in spite of all payment made by the petitioner from OTS amount, and and that third party who has no right title over the property, who has filed a civil suit merely, there is no interim order. So he cannot, the bank cannot arbitrate it withheld the property document or no due certificate and close the account.
No, it is not because of that. There is a legal impediment for them.
Well, there are decisions of the apex court also. If a civil suit is pending, the lordship will not entertain the writ application.
Kindly have a glance at Kerala High Court and Delhi High Court and Odisha High Court have also said once the payment has been made, full and final payment has been made, and a civil suit is filed by the third party.
Have you filed your written statement?
I have filed
civil suit.
Civil suit filed করছি, civil suit pending ଅଛି.
So you can.
I am the businessman.
You can make a prayer there also that for this relief which you are seeking for, can it be made in not?
ହଁ ଠିକ ଅଛି ଡକ୍ୟୁମେଣ୍ଟ ନହଉ କିନ୍ତୁ ମୋର ଆକାଉଣ୍ଟ କ୍ଲୋଜ କରି ମୁଁ ବିଜନେସମ୍ୟାନ ମୋର ସବୁବେଳେ ଦେଖଉଛି ଏନପିଆର ଅଛି 2 କୋଟି ଟଙ୍କା ଅନ୍ୟ ବ୍ୟାଙ୍କରୁ ମୁଁ ଲୋନ ପାଉନାହିଁ ଆକାଉଣ୍ଟ କ୍ଲୋଜ କରିଦିଅ
No, it is all relating to Schedule A or not?
Relating to Schedule A and Schedule B কিন্তু entire amount has been paid by me, entire OTS amount, a single pie has not been pending against me.
Move the concerned court for that. If any order is passed, then you come.
Interim order has not been passed by the civil court. There is no interim order passed by the civil court for return of the good, and even if the civil court can impound the document under Order 13, Rule 8, Order 7, Rule 70. Can Supreme Court document? I am harassing.
କେତେ ଜୋର ଆପଣ submission କରୁଛନ୍ତି?
See, High Court will not ordinary malord and exercise.
Force ରହିବା ଉଚିତ. Submission ଟା ଜୋରରେ ଖାଲି କରିଦେଲେ ହବନି. ତା ଧୀରେ
I have strengthened in my submission.
Just a minute.
Para 6 malord may kindly see. Because it was in a slightly different context, but a suit was pending, my lord. There, the apex court held para 6 re agya dekhibe because the factual aspect is slightly different. My lord. There, my lord, of course, slightly different context. Mr. Arun Jaitley, the learned counsel appearing on behalf of respondent number 1, has supported the impugned judgment on the ground that the prayer for issuing a direction against Delhi administration and Commissioner of Police were respondents 1 and 2 were also made. It has to be appreciated that the present appellants were respondent number 3 and 4 before the High Court, and the High Court has by the impugned order considered it fit to allow the prayer of the respondent against them for removal of the grills for access to the backyard. According to the stand of the landlord respondent, since the police were taking a partisan attitude against her, the filing of a writ petition became necessary. We are unable to follow this argument. There is no doubt that the dispute is between two private persons with respect to an immovable property. Further, a suit covering either directly a portion of the house property which is in dispute in the present case, or in any event, some other parts of the same property is already pending in the civil court. The respondent justifies the step of her moving the High Court with a writ petition on the ground of some complaint made by the appellants and the action by the police taken thereon. We do not agree that on account of this development, the respondents were entitled to maintain a writ petition before the High Court. It has been repeatedly held by this court as also by various courts that a regular suit is the appropriate remedy for settlement of dispute relating to property rights between private persons, and that the remedy under Article 226 of the Constitution shall not be available where violation of some statutory duty on the part of the statutory authority is alleged. And in such a case, the court will issue appropriate directions to the authority concerned.
Property belongs to him.
Property belongs to him.
Now he kept it under mortgage. Now this ultimately he has succeeded and all your amount has been deposited. So the auction purchaser has perhaps filed the suit that since I have also deposited the money, then it should be given to me. Perhaps that is
entire amount with interest has been returned to that.
Mr. Counsel, are you remediless before the civil court with regard to your prayer? Are you remediless that you have come here?
Because
are you remediless before the civil court?
civil court filed by third party.
Are you remediless?
Can you not file any question?
Whether under any provision you have a right to agitate your matter before the civil court during pendency of the civil suit? Are you remediless? You can come here only when you are remediless. Otherwise, the subject matter of the whole dispute is before the civil court. Can you not make a submission before the civil court to redress your grievance?
Decision, my lord, directly.
I came here only because they are harassing me.
No.
No.
Harassing means what? They are not giving you the key. They are not giving you the no due certificate.
My lord.
So, are you stopped from filing any petition before the civil court for redressal of this grievance, for which you have come in the writ? Are you aware of the provisions of the civil court?
Yes, my lord.
Then you file a provision. There is a provision. You have filed a written statement. Yes. No. You make a specific claim before the court.
Filing an appropriate application there.
Go through it.
Then by invoking the writ judicial power, the court can direct the civil court.
It is only when that court has no power to issue a direction. The court has ample power to issue a direction, provided you make a mention before that court in proper application.
We are disposing of this writ petition with that observation that it can. This writ petition has been filed by the petitioner
to direct the civil court to expedite into so that I
you make application before the court.
My lord, with great humbleness, they have already filed a petition on Order 7 Rule 11.
That
they
is
are not pursuing.
That is not the provision. You go through the provision and file.
That also
is
they can avail of.
Prayer or a direction to the opposite party number 2, Chief Manager cum Authorized Officer, UCO Bank, Baleswar Bank, to hand over the keys of dwelling house situated over Schedule B land, documents, no due certificate of the mortgage property. Mr. Subrat Mishra and counsel appearing for the opposite party submits that the keys of the dwelling house situated over Schedule B land has already been handed over. Right?
Pursuant to direction of this Honorable Court in January 2024.
Of this court
dated
January 2024.
January.
The directions that the observation of the court kindly have a glance. That হচ্ছে 22/24 পারা 2 রে পারা 2
order dated 22/1/2024. However, so far as
Schedule A
documents and no due certificate of the mortgage property is concerned, the one civil suit bearing कितने number paragraph paragraph कितने था
1853
CS number 1853 of 21/2142 of 2023 has been filed by the auction purchaser for declaration of right title interest of the Schedule A land before the Land Civil Judge Senior Division Baleswar, wherein the petitioner as well as the bank are the defendant. Land counsel for the petitioner fairly submits that the petitioner has already entered appearance in the civil suit and written statement has also been filed, right? But the civil suit has direction should be issued to the so and so for expeditious disposal of the same. The learned counsel for the opposite party bank submits that the prayer which has been made here can be also agitated before the concerned civil court and it is to be adjudicated in accordance with law. In view of such submission made by the land counsel for the respective parties, if any such application is made by the petitioner before the Land Civil Judge Senior Division Baleswar in CS number 1853 2142 of 2023 relating to the handing over of documents and no due certificate of the mortgage property by the bank to him. The same shall be adjudicated in accordance with law. It is made clear that we have not expressed any opinion on the merits of the application which is likely to be filed by the petitioner. This falls off, yes.
My lord, one line, by one line may be added. The auction purchase has been returned the interest amount received.
Decision note for the
That about WS nahi ki?
Learning Council for the bank has placed the ratio in the case of Mohan Pandey versus another versus Usharani Raj Dharia, reported in 1992 for Supreme Court cases 61, where it has been held that the dispute is between two private persons with respect to the immovable property, and
line is a para 6 road. High Court cannot allow the procedural jurisdiction to be used for deciding.
That is because that is specifically two private.
And in such cases,
may not totally applicable.
High Court
that is the misleading decision.
And
we are not.
Yes,
that is a regular suits one.
Lordship has not decided on FTT issue
the
open to you.
However, the Learning Council for the petitioner submits that the ratio laid down in the said case is not applicable in the facts and circumstances of the case.
expediently hearing करवा पे civil court को direction दिया तो.
If the Learning civil the Learning Swan shall do well to expedite the hearing of the case number.
Obliged.
Obliged.
Item 30.
So item 30, Malaj, we have received the counter from the opposite party number 2, Malaj. Learned District Judge Kalahandi Bhavani Patna will file it. We file the counter within a week, Malaj.
You have received the Parawai summons?
Yes, Malaj.
All right. The Learning Council for the petitioner is present, and Learning Council for the state submits that he has received the Parawai's comment from the District Judge Kalahandi, Bhavani Patna, opposite party number 2.
Yes, Malaj.
And he prepare the counter affidavit and file it within 2 weeks.
Yes, Malaj.
2 weeks.
I'm obliged.
Matter be listed on such and such date. Copy of the counter affidavit be served on the Learning Council for the petitioner in the meantime.
I'm obliged.
Yes, after then your lordship has an order.
Malaj, this time we'll file it, Malaj. Will not take time, Malaj. It is there.
Last time it was listed on 14/8/20.
Yes, Malaj. It was in the month of August, Malaj. We followed it up and we got it, Malaj. Next time will not take time.
Second week of January, my lord.
Okay. So same prayer was made, Mr. Vera.
Yes, Malaj. I saw that, Malaj. That's why we ensured that it will be filed, Malaj.
ନାଇଁ ଆପଣ ଯଦି ଅଗଷ୍ଟରେ ଆପଣ ସେତେବେଳେ ମଧ୍ୟ ପାରାୱାଇଜ କମେଣ୍ଟ ରିସିଭ କରିଥିଲେ ଏବଂ କହିଲେ ଯେ କାଉଣ୍ଟର ଆଫିଡେଭିଟ ଫାଇଲ
ହେଇ ନଥିଲା Malaj.
4 ମାସ ଧରି କଣ କରୁଥିଲେ ଆପଣ?
ପ୍ରିପେୟାର ହେଇପାରୁନି Malaj. I'm sorry, Malaj. I verified that, Malaj. I'll ensure that it is filed within this vacation, Malaj.
We are just coming with it.
My lord, second week of January.
May I pardon? May I pardon, my lord? Item 28, non-appearance of OP3. Item 28. 28 non-appearance for OP3 may be deleted. In another court, so delay. Urgent to 13.
Oh, somebody
My lord,
perhaps sought for adjournment in this.
my lord, urgent. But
You are for the
OP3, my lord.
OP3 টা non-appear যদি থিব কাটি যাবে। All right.
Item 31.
In this case, I am for the appellant. There is nothing that counter-affidavit by OP and 3-4. Copy not served, my lord.
Who is for the opposite party number 3 and 4? 3 and 4 के देखिए।
But I have entered by no counter.
Just a minute. Sub-Director Jagatsinghpur and 4 is Child Development Project of CDPO. Upon file कर देनी counter affidavit. अदा copy देने नहीं? And you are appearing for whom, Mr. Counsel?
Private opposite party, my lord.
अच्छा, that is respondent number 5.
5.
Have you received the counter affidavit?
No, my lord, I have not received.
All right. Land counsel for the. No, it appears that counter affidavit has been filed by opposite party number 3 and 4. That is Sub-Collector Jagatsinghpur and CDPO Raghunathpur. The land counsel for the petitioners, also the land counsel for the respondent number 5 submits that they have not yet received the counter affidavit filed by the opposite party that there is a respondent. So, respondents number 3 and 4. Let the land counsel for the state serve the copy of the counter affidavit on the land counsel for the appellant, the petitioner, their appellant. So also on the counsel for the respondent number 5 within 1 week out of this matter, give a date after Xmas holiday. Yes.
Madam, another thing that I have with due with prior consent from the previous counsel, I have appeared in the case, my lord. My name is Satyaprakash Dhol, my lord. Others name may be deleted, my lord.
This Vibhuti Bhushan Naik Swain
Consent.
Correct. Since Mr. Satyaprakash Dhol and his associate has already entered appearance with on consent of the previously engaged counsel, the name of Mr. Vibhuti Bhushan Swain and his associates shall not be reflected in the cause list henceforth. Yes.
Item 32.
No, item 32, my lord. I have filed the intervention petition on the basis that the averment made in para 5, the acquired land of the petitioner, that means the present petitioner, under Khata number 293, plot number so and so, have been acquired. For that reason, I had filed the intervention petition because it is the land of the present intervener. In the intervention petition, I have
was taken.
So, but on the I found that in the LA case, this Khata plot is not there. So I want to withdraw.
Acha, IA number 9757 of 2024, the London Council for the petitioner for the intervener seeks permission to withdraw the interim application. Accordingly, is disposed of as withdrawn. IA number 97557 of 2024, disposed of withdrawn. Yes.
My lord, sir, and the state is to file counter. The land acquisition officer, my lord, has spread that since there is a civil dispute pending, for him to be able to give that counter, he has to collect documents from different sources, especially because the courts are all around. So he's prayed for about a month's time to collect the documents so that we can file
counsel for the petition.
My lord, I beg to submit, my lord, as per section 64 of the Land Acquisition
I
Act.
am the petitioner here also.
ଅନ୍ୟମାନଙ୍କ ପାଇଁ ମୁଁ 6 to 11 ପାଇଁ ମୁଁ ଅପୋଜିଟ୍ ପାର୍ଟି। The petitioner has not made any application before the collector. For that reason, he has no right to file intervention petition before the land acquisition authority in LA case. So
on that ground, that has not been rejected. You see, in that matter, notice has already been issued, and the
I
state
have
has to file the counter affidavit.
I have filed the counter affidavit.
You have filed it, so like the Land Council for the state submits that 4 weeks time may be granted to file the counter affidavit. Put of this matter, such and such date. Counter affidavit will be filed in the meantime, serving copy on the Land Council for the petitioner, to also the Land Council for the opposite party number 6 to 11.
6 to 11.
Well, I pray I may be accommodated with the adjournment before the original authority may not. The proceeding is going on. So that may be.
Unless this application,
I have
writ
filed an
application is
application
allowed.
for stay for the proceeding. You are not made a party there.
Yes.
So how can you interfere in
My lord, my intervention application has been rejected by the authority.
Right.
That order I have challenged.
Subject matter of challenge here.
Yes, Lord.
So unless the prayer is allowed, how at your instance that case would be adjourned?
Lord, during pendence of the writ application, my lord, the proceeding can be disposed of. Then my writ will be infructuous ultimately.
What is the status of that case?
That is now pending, my lord.
LA case number 9 of 2017.
Now it has been renumbered, my lord.
What is the number?
He has filed the suit and
Renumbered
also
has been lot,
file application before the collector and
say the next date. Yes, next.
53 of 2022, your lordship. The LA number, my lord.
Yes, next.
My lord, I will file the appropriate application. The adjournment will be accommodated, your lordship.
File your application.
Now they are not giving the time, my lord.
You are not party. The party can file, not an outsider who has not been arrayed as a party and whose application for
I am not an outsider, I am the co-sirer, your lordship.
Maybe that your application has been rejected. That is the subject matter of challenge here. And we have to decide. Now let's say that you are permitted to file, and at your instance, it is like that allowing a prayer in this.
I am praying only adjournment, your lordship. Till the disposal of the writ application, my lord.
Yes. Next.
Item 33.
The petitioner, my lord, opposite party has filed a counter. My lord, I need to file a rejoinder. So kindly grant me some time to file rejoinder. And also
Second senior advocate appearing for the petitioner submits that he has received the counter affidavit filed by opposite party.
Opposite party, sole opposite party.
Union of India.
So Union of India, opposite party.
Kahar counter affidavit
They change the private opposite party number 1.
Opposite party number 1, Pratap Kumar Patnaik.
Yes.
And he intends to file the rejoinder to this counter affidavit, and the matter may be taken out.
Second,
week after Xmas for it.
Xmas for it. After take 3 weeks more time than
third week of January.
Second week of January.
Second week of both matter place.
Yes, second week, fourth week, and third week. Third week in fourth week. We commence 20th melody or second.
Week jaha bose dekhi lekhi deba.
Oh, do please. Hello, entry model may continue.
Entry model to continue.
Item 34.
34, Mr. Acharya.
And for the petitioner.
I am appealing for the opposite party.
Lordship, may kindly take the last order. 1/10/2024. 10/2024.
Lord, I've prayed for some time.
The Land Council for the opposite party number filed status of the bank guarantee in the court today, which reveals that bank guarantee has been extended till so and so. The same is on record. Counter affidavit wise somewhere the itna. This application has been filed by so and so. Added as a party. You have carefully gone through the government so and so. What order was intervention petition to be joined as a party to the present writ petition. So that was intervention application was allowed.
Rejected.
Rejected, madam.
Rejected.
Yes, madam.
Should we join?
Madam, I am for the opposite party number 2 and 3.
Direction to release the bank guarantee. Now what do you want?
2 weeks time to file counter affidavit violation for OP number 2 and 3.
Your lordship is the second.
How many times he has to? Urgent.
2 times, your lordship. 24/9.
24/9. You are for the petitioner.
Yes, your lordship.
You are for which opposite party?
And 3, my lord.
MCL.
Land counsel for the opposite party number 2 and 3.
I am appearing for opposite party number 4.
Party number 4.
Mine.
Land Mr. Niyamati is present for the opposite party number 4. Land counsel for the opposite party number 2 and 3. 2 weeks time to file the counter affidavit. Land counsel for the petitioner opposed to such adjournment, as earlier adjournment has already been taken for such purpose. Be that as it may, put up this matter in the 3rd week of January 2025. It is made clear that no further adjournment shall be granted to the opposite party number 2 and 3 to file the counter affidavit. Yes.
Obliged.
Bank guarantee of 6 crores. Work is long since over, everything is over. 6 crores bank guarantee they are withholding.
No,
for no reason. For last 2 years.
No further adjournment and counsel. Yes, next.
Obliged.
Item 35.
35, my lords, notice was issued to private opposite parties. It appears as AD is not back from opposite part number 5 yet. In the first sub item.
Opposite party number 4. But who is for the opposite party number 1, 2, 3?
I am there.
You are. You have filed your counter.
Not yet, man. Not yet.
Not filed.
So I'll file.
So, AD received that. AD from opposite party number 4 has been received after valid service. Notice on so and so is held to be sufficient. So far as opposite party number 5 is concerned, since AD is not back, let that is called postal tracking. Postal tracking.
Man, it has been in past more than 1 month. Let it may be treated as sufficient. Unsolved copy has not been returned.
No, let it come. Let it
come. Postal
knowingly appear
opposite party number 5 be obtained. Land counsel for the state. That is opposite party number 1 and 3. 1 to 3. 6 for an adjournment for 3 weeks like those. 3 weeks to file the counter affidavit. Put up this matter. Get date de dev, January 2025. Postal tracking report.
Item 36.
This is to come along with the audita lagichi ache, WPC settle activity. Yes, item 36, Mr. Das.
May please, Your Lordship.
Yeah.
Is sir a copy of the IA on me now?
IA mane kon thing hai?
So interim application magichandi.
Which IA copy you saw?
This IA is for they have started the
number of that. There are
IA is 12945. 12945.
Why have you filed that IA?
This IA is filed when the dependency of the writ application, wherein I have challenged the order of the learned DRAT. Now, the auction purchaser to whom the property is now restored. Now he's proceeding with the construction. So I have filed an IA for restrain him for carrying out the construction pending disposal of the writ application.
You are for the
I'm for the I'm for the petitioner who was the appellant before the DRAT.
No, you are the borrower.
No, the borrower was one Tarak Nath. I was one of the auction purchaser who was allotted the property. Yes, who was allotted the property, and now I was directed by the DRT to pay the rest amount of 2 crores. And then I had paid it before the DRT, while the auction purchaser from whom my learned senior is appearing and the bank, they approached the DRAT in two subsequent.
You are one of the auction purchasers.
I am one of the auction purchasers.
And he is also one of the auction purchasers of the same property.
The same property.
And successful property.
He is also one of the auction purchaser. I had given an offer of 4 crores, whereas the price of the valuation was of 5.25 crores. Learned DRT accepted my price bid, and Learned DRT accepted that yes, I have deposited around 2 crores, and now DRT has passed an order that subsequent to this, since there has been undervaluation of the property, you give 2 crores more, and then the property will be allotted in your the property will be executed in your favor. However, my lords, against the order of DRT, the auction purchaser, I mean for whom my learned senior is appearing, and the bank, both of them went to the DRAT in two appeals. Well, in that appeal, the learned DRAT has set aside the order of DRT, and they directed that an amount of rupees 2 crores should be refunded to me with interest, and they restored the auction in favor of the auction purchaser.
That order has been challenged.
That order is challenging this writ application.
Okay. Now the pleading is complete. Question is that why have you filed this IA today, which has come for consideration?
I am to file counter in the main writ petition, Your Lordship.
Counter affidavit.
No, by the way, what is your prayer in this IA?
The prayer in my IA is to restrain
the action purchaser.
I have taken possession since
not to take any
2019.
construction over the scheduled land.
2019, I am in possession.
Because otherwise, then
And my lord, he is also proceeding before the DRAT for withdrawal of the amount. This for 2 crores that he had deposited.
The
balance 2 crores was never deposited.
IA number 12945 of 2024 is an application for passing appropriate order, mainly for a direction to the opposite party number 5, that is Hindustan Agency, represented through his partner Vikas Kumar Bhoot. Not to make any construction for the civil land pending disposal of the writ petition. The land counsel for the opposite party number 5 submits that he has received the interim application copy in court today, and he seeks some time to go through it and file the counter objection to the so-and-so, and the matter is stayed after ensuing Xmas holidays. List this matter on such that he has made.
Lordship, fix a date once.
It will be in the either second week or third week. Just see the date in the evening hours in the High Court website.
In this case, I am appearing for opposite party number 2, 3 and 4.
ये जो item number 36 है, 36 रे 36 रे Mr. Niyamatin को presence note down
for bank
2, 3 and 4 question है ना? All right.
Item 37.
37, my lords, I was supposed to get instructions on the whether the vacancy list has merged. Those instructions, my lord, with our High Court, my lords, administrative side. I have written, my lords, to the Law Department, has written to the Registry Administration. My lords, may kindly grant me some time, I will get those instructions.
There, my lord, your lordship will see how many times your lordship has been pleased to grant time. I have filed one IA. Kindly consider my IA in that case. Otherwise, what happens? My whole cause will be frustrated, my writ will become incompleted. The ground on which I have filed the writ petition is the vacancy has remained unfilled because the selected candidate was given time of extension till a particular date. Before that date, the advertisement was made, meaning thereby the vacancy was not included in the fresh advertisement. So that being the position, I was before my lords. Probably I'm not clear. But the vacancies were advertised, select list was prepared, a particular candidate did not join.
That is
Serial number 3
Ananya Mishra.
Right, C did not join. C was allowed an extension for the purpose of joining up to 12th of April 23. Now, before that, fresh vacancies were advertised. So, two things were corollary to this. One, the vacancy for Ananya Mishra was valid up to 12/4. The new vacancy advertised is before 12/4. So, vacancy was definitely there at the time of advertisement, before even thereafter also. Am I clear, my lord?
Yeah.
So that being the position, today that vacancy is still there. Now, in the future advertisement.
No, still there or not there, that is the instruction he wants to obtain for that.
So for that purpose, kindly see the order, how many dates they have taken. And today I have filed one IA. Your lordship will kindly consider that. Once the
which is the IA?
The IA is 17024.
You have received the copy of that.
Seem to have. No, I don't have that IA, my lords. Copy may be served, my lords. If it was given in email, my lords, I haven't received.
Copy has served.
Another copy may kindly.
That's a different matter for you. Please don't say that you have not received.
17024 of 2024, there is an application for appropriate order.
Yes.
The Land Council for the state submits that is yet to receive the copy of the interim application. However, Mr. Rotherland, senior advocate, submits that the copy has already been served in the AG office. However, he will hand over the copy of the interim application during course of the day to the Land Council for the state. Land Council for the state system for the time.
This is the receipt.
I'm not disputing it.
The copy is there to quite Land Council for the state system for the time to file the counter affidavit, to which Mr. Rotherland, senior advocate, opposed on the ground that already some adjournments have already been taken by the Land Council for the state. This matter in the week commencing from the second week touch held with third week represent. It is made further clear that no further adjournments will be granted. Yes.
No, please.
And the counter objection, if any, so and so to that I be filed also meantime, giving this copy to Mr. Rowe. Yes.
Item 38.
My instruction in the month of December, the press advertisement is going to come. But in that case, the only protection your lordship may grant that the vacancy meet for that serial number 3, if at all is made part of the advertisement, the same shall be subject to result of the at least to that extent the protection be.
But to that extent, yes, the position of law is in your favor.
Position of law. I could not follow it.
The position of law vis-a-vis the last decision of the Supreme Court. That if there is a select list,
yes.
In that case also we once
that's fine. Right. I am not asking about that, Lord. Your lordship will find, Lord, here they have completely violated the Supreme Court's order and the selection procedure is contrary to the rules. That's the point. But yes. If that protection can be granted.
We'll see.
30.
Item 38.
On the fictional matter, the petitioner's property, mortgage property already been sold matter. But come to page matter 31.
For the opposite party number.
The summons were issued and already happened.
My lord, I am praying for time to file the counter, my lord.
You are for the
OP3, my lord.
I have no against opinion 3, my lord. I have no my
you are for the petitioner.
My line for the petitioner. What happens what from mortgage property was sold, man.
Which for the bank, Mr. Bishwa?
Yes, madam. In this case, what happened?
Yes.
Now the property was mortgaged. There is a surplus amount, and when you offer the surplus amount, the opposite party number 3 has filed a suit. That is not till date it is pending, my lord. So for that reason, we are not in a position, because if both of the brothers will not give a consent to give the rest of the amount to them, then we cannot give the same to one person, because suit is pending. He is praying the recovery of the possession of the property, my lord. It is a joint property. So we are in a
just a minute.
What happens?
Petitioner and opposite party number 3 are
two brothers.
Yes.
Okay. So the property in question was put to e-auction. Right. Then now what happened there?
E-auction is successful and possession has been handed over.
That means the extent of borrowed money has been taken by the bank. So there is some surplus
amount. We gave notice to
that is to be whether that is to be paid to the Mr. X. That
no. We have told that we will divide it between 2 and give it to them. The surplus amount. But he has filed a suit. Opposite party number 3 has filed a suit for recovery of the possession of the mortgage property, which has been sold.
Oh, recovery.
and we are not in a position to give it to anybody else.
Yes.
I'm sorry. Last time, before Woodall order, my order has directed and uncertain to harness the food plant matter. That is food plant is matter. I am not very, I am not party matter. That is page 44 matter. Clarify matter. Page 44 matter. It's a visual is not correct matter.
अरे कौन टा कोच
Page 44.
तत्तर हुँदुनी कौन टा
Matter page 44 matter. The suit is pending, which is claimed by Vishal.
Just a minute.
Page not 44 matter.
44 अच्छा CH number so and so of 23 it has been filed by one अरे ठीक है रुहନ୍ତୁ
रुहନ୍ତୁ କାଇଁ ତରତର ମୁଁ କଣ କହୁଛି ମୁଁ କହୁଛି ତମେ କଥା
प्रदीप कुमार asked किए
copy number 3
so you have filed the suit
No matter, I have not filed suit.
रुह ତମେ କଣ ବୁଝୁନ କଣ ପଚାରୁଛନ୍ତି କୋର୍ଟ ନ ବୁଝି ଖାଲି କହିସାରିଛ କି ସରିଯିବ କେସ୍ ଟା
ପଚାରୁଛୁ ପ୍ରଦୀପ କୁମାର ଆସ୍ କିଏ
Pradeep Kumar
Copy
Aas is
3
my
man.
brother, man.
opposite party number 3
3
ପଚରାଉଛି so why he has filed this suit it is for suit for permanent
injunction.
So now in
46
this
is the prayer.
Acha, in this case only the opposite party is the chief manager acha. And he has sought for relief that is in paragraph number 10 that permanent injunction to be issued against the defendant so and so with respect to so not to evict the plaintiff from the suit land. Alternatively, this plaintiff is ready to pay the outstanding dues of the sworn.
It was before mortgage sold before.
Then another prayer. Let this suit be decreed for realization of post litigation expenses and others from the defendants and the favor of the.
It was sold. It was filed matter. Thereafter, mortgage property was sold and handed over to the third party. Now I am also not party in this case. But my lord, before that, my brother has also filed a partition suit. That is 34 matter. Partition suit. Brother has.
Why are you not taking steps to be included in this particular suit? अरे क्या?
What happens? My brother is not interested to give his affidavit. Man. What happened? Page answer 9 man. Answer 9 I am clearing answer 9 man. Page 27. It is clear man. যদি ন দেবে দুই জন
কোন ব্যাংক তো প্রস্তুত ଅଛି ସେ
bank is getting missing man. What happens? I am not party in the suit man.
ସିଏ ନ କଲା ଯେ ଉଠ୍ର ଆମେ ଦେଇ ଦଉ ତା ପଇସା ପୁଣି ଇଆଡେ ପଇସା ହରେଇବୁ ଘର ବି ଯିବ
ବ୍ୟାଙ୍କ କାହାକୁ ଦବ ବ୍ୟାଙ୍କ କାହାକୁ ଦବ
ସେ ମୋ ପ୍ରେୟାର ଅଛି ମୋର 50 I am କାହିଁ ନା ସେ ଇଏ ପାର୍ଟିସନ ଡ୍ୟୁଟି କରିଛନ୍ତି ସେଟା ଦେଖଉଥିଲେ ପେଜ 44 ମାନେ
ଏଇ ସବୁ ଜିନିଷକୁ ଆପଣ ଯଦି ଆଦେରେ ସୁଟ୍ ରେ ଯଦି ଇମ୍ପ୍ଲିଡ୍ ହେଇକି
ଏଗୁଡା what happens I am 34 ମାନେ କାଲି ମୋମେଣ୍ଟ
ଆପଣ ସୁଟ୍ ରେ ନିଜେ ପାର୍ଟି ଅଛନ୍ତି
ନା ପାର୍ଟି ନାହିଁ
ଇମ୍ପ୍ଲିଡ୍ ହୁଅନ୍ତୁ ଇମ୍ପ୍ଲିଡ୍ ହେଇକରି ସେଠି ଗୋଟେ ପିଟିସନ ଦିଅନ୍ତୁ ମତେ ଦିଆଯାଏ ବୋଲି 50% because you have already
34 my
you had earlier filed a suit or not?
No man, I am not filed suit.
Come.
Man.
Pradeep Kumar As.
Pradeep Kumar As is brother man. I am Dilip Kumar As.
Pradeep Kumar As had filed a suit earlier in 2000. Wait. In 2015 he has filed a suit.
Suit for partition man.
Wait. How much share he had claimed?
50% man.
It was allowed or not?
Allowed. That is
allowed.
My claim is
so try to understand. So what prevented you not to be a party in the civil suit and ask for 50% to the court?
Page 42 man. I'm grateful man. Page 42 man. Partition order. That is different plenty.
That is what I am saying. This order has been passed in 2019.
19 man. That is binding man.
So you be a party in this suit and claim your 50% to be released before the court.
Our letter is
that is the order.
Madam, that is the bank letter, madam.
No. You go because the matter is what they are saying. They are saying that the matter is sub judice before the civil court. So they are not in a position to make you the payment. So you appear before the civil court, file an application.
Page 27. Bank's letter itself, madam. Page 27 may be seen kindly, man. Page 27. I am claiming only 50%. I am not claiming.
Again, you are saying.
What is your instruction, Mr. This your brother has.
Page 27, madam, may be seen.
ଆପଣ ଗୋଟେ କଥା
ବୁଝି
କହିଲେ
ପାରୁନାହାନ୍ତି ଆପଣ
ବୁଝି ପାରୁନାହାନ୍ତି ନା ତରତରରେ କହୁଛନ୍ତି ନା ହାବିଟ ନା କଣ ଯେତେବେଳେ ଜଣେ ପଚାରନ୍ତି କୌଣସି ପ୍ରଶ୍ନ ଜଜେସ୍ ପଚାରନ୍ତି your first duty is to listen carefully what he wants to know because ultimately the order has to be passed by us ଆମେ ପ୍ରଶ୍ନ ପଚାରିବା ପୂର୍ବରୁ ଆପଣ ଉତ୍ତର ଦେବାକୁ ଆରମ୍ଭ କରୁଛନ୍ତି ଆପଣ କେମିତି ବୁଝିବେ ଜିନିଷଟା ଆମେ କଣ ଚାହୁଁଛୁ ଆପଣଙ୍କର ପ୍ରଶ୍ନ ପଚାରୁଛି ଆପଣ ଭାଇ ଗୋଟେ ସୁଟ୍ ଫାଇଲ କରିଥିଲେ ସିଭିଲ ସୁଟ୍ ନମ୍ବର 695 of 2015 that is the page number 34 ହେଲା ସେଇ ସୁଟ୍ ରେ ଆପଣ ଥିଲେ ଡିଫେଣ୍ଡାଣ୍ଟ ରାଇଟ୍ ସେଥିରେ ଅର୍ଡର ହେଲା the operative part of the order is that the plaintiff and the defendant are entitled to half share of each over the suit land. এই অর্ডারটা 2019 মସିହାରେ ହେଲା 2019 we are in 2024 any of you has challenged this order?
No madam, I have not challenged.
So that has reached finality. ଆପଣଙ୍କର ଭାଇ ବର୍ତ୍ତମାନ ଆଉ ଗୋଟେ ସୁଟ୍ ଫାଇଲ କରିଛନ୍ତି ହେଲା in which you are not a party.
Before a mortgage sold, property was mortgaged to sold. File was 23.
23 in which you are not a party. Please try to understand it. So ଆପଣଙ୍କର ଆପଣ ମଧ୍ୟ ଚାହୁଁଛନ୍ତି ଯେ ମତେ 50% ଦିଆଯାଉ ବୋଲି. So why are you not taking any steps to be included as a party in that particular civil suit which has been filed by your brother claiming the entire property?
Plaintiff is the master of the suit. Plaintiff if not added me in
no plaintiff is dominus litis that we know, but when you claim yourself to be having interest in the property, can you be prevented from becoming a party?
In the meantime,
we are aware of the fact that the plaintiff is dominus litis and plaintiff will come with the party which he intends, that we know.
Property decree has been passed 1/2 property already sold man. More SS property amount has to be written. Bank letter, it's a bank letter, it's 27. Page 27 clarifying. Page 27
you redress your grievance before the civil court.
This writ petition has been filed by petitioner Dilip Kumar Das with a prayer to the opposite for a direction to the opposite party bank to return the surplus money with interest got from the e-auction dated 27/1/2023 of the mortgage property against the loan account to the half share of the petitioner as per later dated 14/12/2023 and with a further prayer to quash the later dated 19/3/2024 issued by the bank. The opposite party bank has filed. You have not filed the counter-affidavit.
No, my lord. In this case, I have
submitted.
I have
that a civil suit was filed
by CS number 390/479 page 44
a civil suit was filed no ta purbur jota aitala jota
695
sir enter land mortgage thila
anyway that was in 15
that a civil suit was filed by Pradeep Kumar
Dash.
But the petitioner is a party also.
Bracket opposite party number 3 against the petitioner before the London third additional senior civil judge Baleswar, and in that civil suit the judgment was pronounced on 26/9/2019 and the it was decreed ex parte against the petitioner and it was held that the plaintiff bracket legontu opposite party number 3 and the defendant bracket legontu petitioner are entitled to one of share each over the suit land. Stop. The Land Council for the bank further submits that another civil suit has also been instituted in the meantime, that is CS number 390/479 of 2023 before the London Senior Civil Judge Balaswar against the bank.
That is on the basis of the liberty granted by this court in writ petition number
As per the liberty granted by this court
in
WPC number
8873
8873 of 2024, disposed of on
26
26/2024.
ନା ସେଟା ତା ଆଗରୁ ଫାଇଲ ହେଇଥିଲା ଆଜ୍ଞା।
ନା 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 କିନ୍ତୁ ଲିବର୍ଟି ଯାଇଥିଲା
ଲିବର୍ଟି ନେଇଥିଲେ ସିଏ ପାର୍ଟି
ଏଟା 24 ଆଚ୍ଛା ଆଉ ଗୋଟେ
ଆଡ କରିବା ପାଇଁ ପାର୍ଟି ନେଇଥିଲେ।
With a prayer,
ଆଚ୍ଛା
with a prayer,
page 46.
Page 46. With a prayer for permanent injunction to be issued against the defendant bank with respect to Schedule A property and not to evict the opposite party number 3 from the suit land. Land and Council for the bank submits that the bank has already entered appearance with the civil suit.
Yes, ma'am.
And written statement has also been filed.
They have stated the copy is not with me.
Written statement has been filed. It is the submission made by the Land Council for the bank that since it is a dispute between the two brothers, even though the bank is ready to make payment of
the surplus
amount, but if the said amount is paid at this juncture and during the pendency of the civil suit, it may create difficulty on the part of the bank. Stop. The Land Council for the petitioner submits that since the judgment and order passed by the London Third Additional Civil Judge Balaswar in civil suit number 695 of 2015, as per judgment dated so has not been challenged by any of the parties, and that has reached finality. There is no difficulty on the part of the bank to disburse the 50% of the surplus amount in favor of the petitioner. Be that as it may, since civil suit is sub judice before the in the petitioner is at liberty to file appropriate applications to be pleaded as a party in the said event. The Land Senior Civil Judge Balaswar shall do well to expedite the hearing of the suit. With such observation, the writ petition is disposed of. Yes.
No, one line more, page 27 ରେ ଅଛି, both parties directed to file affidavit. The failure and reading one line, failure to comply with the above request.
The parties are cooperate.
My lord, OP3 appearance.
My lord, I'm reading one line.
Next.
My lord, OP3 appearance, my
May I make a mention, my lord?
OP3 appearance.
May I make a mention, my lord? For item 22, my lord.
54 my lord, mentioned before my lord, give me taken my lord.
Supplemental list, item number 1.
केस पड़ीगला पड़ेला से भी ये पास
अच्छा
On 4th in 2020, order dated 4th in 2020, United Motors engaged as a appeal case. And thereafter, Mr. Sahoo name is another order. That is 7/1/2021. Mr. S.K.Sahoo Hon'Ble, the appellant submitted that he has not responded. Both the counsel is there. Name is there.
No. What he says, whether he is.
they will do the case man. Paper book is with him.
Then where is he today?
Is there a case पड़ेगा पड़ेगा.
No, if you will not come, then we'll delete the name and we'll engage. Ms. Das is there, Mrs. Das is there, she will argue the matter. खबर दियो तो
इन्फॉर्म कर दूँ.
ठीक है. Next.
Item 2.
May I please, your lordship, I am on behalf of the petitioner.
What is your good name, learning counsel?
My name is Israel Khan.
Israel
Khan.
I Khan. अच्छा Israel Khan.
So there is a prisoner's petition here, which has been filed by appellant number 1 means Nando alias Prashant Kumar. So he has requested to engage Mr. Subhash Chandra Rathore instead of S.K.Sahoo Hon'Ble.
I am on behalf of the Subhash Chandra.
Subhash Chandra Rathore. You have already filed for. How many appellants are there in this?
In this case, we are appealing only for Prashant Kumar Pradhan.
Nanda alias
Prashant Kumar Pradhan. Praying for bail, my lord.
Just a minute. Okay, 2 persons face trial, but the prisoner's petition also came from 2, and that is how the engagement was made to Mr. Ashok Kumar Swami. And then Mandakini Panda came into picture, and you have filed only power for this appellant number 1.
Nanda alias Prashant Kumar Pradhan.
So, what is your submission?
My lordship, the petitioner is in jail custody more than 17 years. So praying for bail, man.
What is the offense here?
302 and 34 IPs.
What is the case of the prosecution? What you have done? Come to paragraph number 2 of the judgment. Have you got the judgment copy with you?
My lord, I have.
Then how can you argue a matter? You are moving a bail application, you are not having a copy of the judgment. Come to that. Paper would be on it. You receive the paper book.
No, my lord.
No. We are giving you the paper book.
Now, here is the paper book.
Huh?
It is the page.
ठीक है, पढ़ो तो paragraph 2 पढ़ो. कौन पाउना जी ना कौन?
Structural find out the prosecution.
Find out.
Foundation.
Factual foundation, the prosecution story is that on 23 June 2006 at about 12 to noon, while informant Ramachandra Malik was going to Jhinki to search his buffalo on the way near Podapanda Ghat road, found both the accused persons, Nanda alias Prashant Kumar Pradhan and Ramchandra Sahu, were assaulting one ferrywala by means of wooden lathi and stone. On seeing the informant, both of them went away towards jungle. Out of fear, the informant came back to the village and informed other witnesses, who rushed to the spot and found the ferrywala laying dead. Subsequently, both the accused persons were caught red-handed by villagers of Dadra. The matter was informed to Y.C. Daspala over telephone in the same night, who proceeded to the spot. After his arrival on 24 June 2006, at about 6 a.m., a written report was presented before him by said Ramo Malik, and he immediately took up registration
Preliminary investigation.
preliminary investigation at the spot pending formal registration of the case. He examined certain witnesses at the spot, including the informant.
PW1 is the eyewitness to the occurrence.
Yes, ma'am.
Trial court record. He is the informant.
Held inquest over the dead body, seized the two wooden lathi and a stone stained with blood.
Doctor here, Mr.
Along with blood, stained earth and sample earth, sent the dead body for post-mortem to area hospital Daspala through accompanying constable, and then went to village Dadra and apprehended the accused persons in presence of witnesses. From their possession, he recovered one mosquito net, 5 numbers of door screens, cash of 785, and Xerox copy of voter identity card, and seized the same.
Are the London Council for the petitioner, London Council for the state. This is that application has been filed by appellant number 1, Nando alias Prashant Kumar Pradhan.
Prashant Kumar Pradhan.
Prashant Kumar Pradhan. The London Council for the London Council for the petitioner submits that the petitioner was taken into judicial custody on 25/6/2006 and he was never released on bail during trial or during pendency of the appeal, and as such he has remained in custody for more than 18 years. And even the paper book has already been prepared, there is no chance of early hearing, therefore the bail application may be favorably considered. Land Council for the state opposed the prayer for bail, praised the statement of eyewitness bracketary PW1, also the doctor bracketary PW9. Considering the submission made by the Land Council for the respective parties, nature of evidence adduced, period of detention of the petitioner in judicial custody for more than 18 years, we are inclined to release the petitioner on bail allowed. Stay relation of fine. I'm the paper book receive yes.
Item 3. Item 5.
No, my lord. Earlier I have given the copies, my lord. Just now my lord and friend requested me to give you another copy, my custody since more than 11 years. That part, my lord, the appendant.
ଆପଣ ଗୋଟେ କରିଦଉନାହାନ୍ତି ଯେ ଯୋଉଟା ଅଫିସ ରେ ଫାଇଲ ହେଇଥିବ ଯୋଉ କପି ସେଇଟା କିଛି ଧରାଯିବନି, ଆଉ ଗୋଟେ କପି ଆମକୁ ଯଦି କୋର୍ଟ ରେ ଦିଆହବ ସେଇଠୁ ଧରାଯିବ। ଆଉ ସେଇଆ କହୁଛନ୍ତି ଆଉ। Prisoner's petition has been received from jail for engagement of Mr. Biswajit Naik instead of Advocate S.R. Das. Stop. Mr. Naik has already filed VNAMA. The prisoner's prayer made in the prisoner's petition is accepted. So also the VNAMA. The name of Mr. Soumyaranjan Das and his associates shall not be reflected in the cause list. IA number so and so for bail. Eta kon is bail?
Millet, he's in custody for more than 11 years, Millet. Millet, both of them, Millet, two petitioners.
Date of custody?
Date of custody, Millet, on 17/9/2013, Millet.
What is the offense you have been found guilty?
Offense, Millet, 302. 302 and 34, Millet.
302 by 34. Please come to paragraph number 2. Let us see the prosecution case.
Millet. About 5 years prior to the occurrence, one Kheti Kandulana, daughter of the Bhukta Munda, belongs to the family of the accused persons, suffered from fever and died.
What is the name of the deceased here?
My lord, name of the deceased is Mangri Munda alias Kandulana.
Jane to?
Jane.
Mangri Munda. Acha, padhantu.
My lord, about 5 years prior to the occurrence, one Kheti Kandulana, daughter of Bhukta Munda, belongs to the family of the accused person, suffered from fever and died. On the next year, Budhwa, son of Bhukta Munda, also died out of electric shock. About 1 month prior to the occurrence, son of the present accused, namely Noro, had been to Jagda, where he felt pain on his chest and died. The family of the accused persons doubted the mother of the complainant, namely Mangri Munda alias Kandulana, deceased, was practicing witchcraft, and she and her husband were behind such death. They picked up quarreling with the family of the complainant, so also threatened to eliminate the deceased. On 16/9/2013, a meeting was organized to discuss the issue at the village, but none from the family of the accused persons attended it. On 17/9/2013, at about 6 a.m., the deceased had been to well, which was situated near her house, to fetch water. At the time, accused Bisra Munda, armed with an axe, accused Sanika Munda, armed with a dauli, chased the deceased and assaulted and killed her in the paddy land of Baya Khalko. The deceased succumbed to those injuries at the spot itself. The complainant PW2, who is the daughter of the accused, lodged a written report at Nuagam police station.
This is in this CRLA sole accused?
No, 2 accused persons are there.
ଆପଣ ଯୋଉ ବେଲ୍ ଟା ଫାଇଲ କରିଛନ୍ତି କାହା ପାଇଁ?
2 ଜଣ
ପାଇଁ. So Bisra Munda was armed with axe, and se jo Sanika Munda was armed with
a dauli.
Dauli kono?
Da bodh.
Mane kono da? Mane sharp cutting weapon?
Sharp cutting.
Okay. Eyewitnesses are there.
Eyewitnesses, they are claiming that PW1, PW2, 3, 4, and 5, the daughters and
1 to 5 are eyewitnesses.
Sorry, my lord, PW1 is the doctor, 2 to 5, my lord.
2 to 5.
My lord.
PW1 is the PM doctor.
PM doctor, my lord.
So what he has seen?
My lord, PW2 is saying that, my lord, she had seen the occurrence, but in the FIR, my lord, if your lordship will see the, my lord, the depositions on the call.
You just come to the PW1, the doctor.
Doctor.
There are inside room, tibia fibula of the left leg, then
chop
on inside
neck, cervical.
Cause of death is so and so, cutting of the left. Eyewitness होचंदी 2 to 5.
2 to 5.
Say कहउचंदी आपण दी जन जाको
2 to 5, Milord, they are saying that, but the IO is saying that, Milord, PW5 was not present, Milord. Yes, Milord. PW3 also was not present. PW2 also in her deposition, Milord, on recall, Milord, if you will see the depositions of PW2 on recall, Milord, page 54. It is a fact that in my FIR I had mentioned the fact that on the day of occurrence at about 6 a.m. while I was going to attend the call of nature, At that time, my mother had gone to the nearby well to fetch water. It is a fact that I have not mentioned in my affair that when my mother saw the accused person, she ran away. It is a fact that I had not mentioned in my affair at the time of occurrence to save my mother, I raised her. It is a fact that I had not mentioned in the affair that after the incident, the accused persons went towards Sahu Basti, and thereafter I myself and my sisters came and found my mother was lying on the field with bleeding injuries. It is a fact that I had neither stated before the police nor mentioned in the affair that when I saw the accused persons were going towards my mother, I told her to leave the space. But in the cross-examination, she has, in the examination of Chief Miller, she has stated that I have seen the occurrence.
No, this is contradiction so far other parts are concerned.
Yes.
What about that assault part? There is no contradictions. There may be
Assault
that
part, Miller,
these are here and there. So main thing, it is a fact that I had paragraph 17 को आसिले
Miller. It is a fact
that I had neither stated before the
police
nor mentioned in the
FIR
affair that accused Bisra Munda
assaulted
my mother on her head
just
near the back ear of the swan. So the contradiction is that particular part.
Yes.
ସେ ମୁଣ୍ଡରେ ମାରିବା କଥା କହିଛି କିନ୍ତୁ ସେ ଯୋଉ କାନ ଇଏ ପାଖରେ ସେଇ ଜାଗାରେ କହିନି. That is the contradiction. Otherwise,
ସେ କହୁଛି ସେ କହିବା କଥା ମୁଁ ଦେଖିଛି but subsequently but the ଦେଖିବା part has neither Millard she has mentioned in the affair nor Millard she has stated before the police.
How many years you are in custody?
Millard.
79. You have never been released on bail during trial.
No, Millard.
Okay, persons in custody. Produced in custody.
तीन ଦେଖିଛି ତ ବୋଲି କହୁଛି ତିନି my lord, if your lordship will see the my lord, I am coming to the depositions of the I.
are saying
My lord, PW, your lordship kindly for a moment, my lord, come to the PW 12 man. 12
no, 2 and 3.
They are saying that, but the PW 12 IO stated that, my lord. For a moment, my lord, I am showing at page 78 man. Or the PW 5 minute stated that she was present at the time of occurrence minute. Paragraph 8 minute. I have examined Buddhi Haro, PW 3. She has not stated before me that the accused persons inflicted clot blows on the head and legs of the deceased. I have examined Ramesh Kandulana, PW 5. He has stated before me that at the time of occurrence he was returning from call of nature.
So detention period is more than 11 years. Are the learned counsel for the petitioner and counsel for the state? The learned counsel for the petitioner submit that the petitioners are in judicial custody. 79.
79 2013.
These
on the same day both of them were arrested and produced
18/9 2013, and they were never released on bail during the trial, and as such they have remained in custody for more than 11 years. It is further submitted that though the eyewitnesses PWs 2 to 5 have implicated the petitioners in the assault of the deceased Mangri Munda, but it has been brought out by way of cross-examination that there are contradictions in their evidence. The Land Council submits that there are good chances of success in the case and balance of convenience is in their favor. Therefore, the bail application may be favorably considered. Land Council for the state, on the other hand, opposed the prayer for bail and placed the evidence of PW1, the doctor who conducted post-mortem examination and noted number of incised and chop wounds and opined the cause of death to be
এটা কোন লেখা হয়েছে ওয়ার্ডটা দেখলে EXSANGUIMATION and hemorrhage soft due to cutting of left neck great vessels and right great vessels. Hello. He also placed the evidence of the eyewitnesses. So also the evidence of the IO bracketary PW 12. Considering the submission made by the land council for the respective party, the nature of evidence available on record, the period of detention of the petitioner in judicial custody, we are inclined to release the petitioners on bail. Allow this next. Yes, Mr. Sahu. So, are you ready to argue this matter?
Next week, Monday, so that.
No. If you can argue, otherwise we can. We have already engaged Mrs. Das, but it is stated that you are received the paper book and you are also ready. So, if you are ready to attend, when the matter is listed, don't take adjournment because it's a jail criminal appeal of the year 2007. So, are you ready?
My lord,
Have you received the paper book?
I have received the paper, but somehow it was missed.
Huh?
Somehow it was missed during the COVID period. But I will collect another paper book and Monday.
COVID period ରେ କଣ ଆପଣ ନେଇକି ଦିଆହେଲା ପେପର କୁ ଆପଣ ଘର ବାହାରେ ରଖିଥିଲେ କିଏ ନେଇଗଲା ନା କଣ ସେତେବେଳେ ସବୁ ପେପର କେହି ରିସିଭ କରୁନଥିଲେ ନା ବାହାରେ ଖରାରେ ଶୋଉଥିଲେ ତ କୋଭିଡ ପିରିୟଡ ଆପଣ କଣ କହୁଥିଲେ ତ ପେପର ବୁକ୍ ଅଛି ଏକ୍ସଟ୍ରା ପେପର ବୁକ୍ again immediately. Get ready, we'll take up this matter. Huh?
Monday, my lord.
Mr. Sahoo and counsel submits that if the paper book may be supplied to him and he can argue the matter next week. That a copy of the paper will be supplied to him in course of the day. You remain and your signature received. That will be added to the hearing. Yes.
Item 6.
May I please, Your the IA for bail, Your that the appellant has been convicted under section 20302 and 201 of IPC, Your and sentenced for life in the 302 and 1 year in the 201, Your
What is your custody date?
Custody date is 21/4/12, Your more than 12 years, 9 months.
Come to the judgment.
Page 4 of the paper book, the para 2 of the judgment. The prosecution case is that the deceased Nomita Lima is the legally married wife of the accused. The marriage was solemnized 1 year before the death of the deceased. At the time of marriage, rupees 10,000 were given as dowry. After marriage, the accused ill-treated Nomita, demanding more dowry. On 19/4/12, the informant, the father of the Nomita, and his wife went to the house of the accused after getting information that their daughter was carrying for 7 months. The informant invited the accused to his house and also wanted to take his daughter to his house. But the accused got angry and refused to send his wife with the informant. He got angry and told that the informant would know the consequences in the next day. In the next day, that is on 24/2012 at 4 a.m., the villagers informed him about missing of both husband and a wife in the village. So the informant came to village of the accused and started searching for his daughter. In the jungle road, he detected some bloodstains and then suspected the conduct of the accused. He lodged FIR with police. On the basis of FIR, IAC Padmapur Police Station registered PS case number 18/12
and took up investigation. After investigation, he submitted charge sheet against the
Case based
accused.
on circumstantial evidence or direct evidence?
Only circumstantial evidence, Your Lordship.
What
No
are the
direct.
circumstances against you?
Three circumstances, Your Lordship. One is the last scene theory. The villager stated that previous evening, both husband and wife were proceeded to the inside the jungle road. And the second is 27 discovery part and a confession of accused.
What was recovered at your instance?
Recover the one tangi and one stick, that is recovered, Your Lordship. But so far the complete the chain of the circumstance.
How can last scene recovery of tangia and stick?
My lord.
How come?
That is and confession of accused. That is only before the police.
Yes. So last scene विषय की कहूँ?
Last scene with all the accused persons that has been discussed in the judgment, Your Lordship. That is para 12 of the judgment, Your Lordship.
No, when they have stated that both of you were going towards jungle.
ପୂର୍ବ ଦିନ 4ଟା ବେଳେ 19 ତାରିଖ 4ଟା ବେଳେ 20 ତାରିଖ ଦିନ ସକାଳୁ ପାଇଲେ
19 ତାରିଖ 19/4/2012
ଆଜ୍ଞା
4 PM ରେ ଦେଖିଲେ ଆପଣ ଦି ଜଣ ଯାକ ଯାଉଛନ୍ତି
ମାଇଲର୍ସ PW1 ସମସ୍ତେ ପ୍ରାୟ ସମସ୍ତେ ଦେଖିଛନ୍ତି ବୋଲି କହୁଛନ୍ତି
married so and so 19 there was a marriage informant so and so attended the at that time Namita was pregnant or so and so 20 kilometers. Acha, following that about two, I found the accused holding a tangia going towards Haria Guda Nalo along with his wife. Cashew top is also situated by the side. They did not return till evening. Okay, the accused alone returned back at 6 PM. So, ତା ପରଦିନ ସକାଳୁ ଡେଡ୍ ବଡି ମିଳିଲା
ବ୍ଲଡ ଷ୍ଟାଇନ୍ ଦେଖିଲା ପରେ ତାପରେ ଖୋଜିଲା ପରେ ଡେଡ୍ ବଡି ମିଳିଲା
କୋଉ ଡେଡ୍ ବଡି ମିଳିଲା
ସେଇ ନାଳ ପାଖରୁ
ଆଚ୍ଛା what is your explanation given in the 313 have you denied or you have stated something
denied simply denied
acha
and the PW 6 7 and 8 they stated that I have proceeded to the spot where the dead body found in the deposition, but the IO lordship, IO examiner PW 18 in cross examination he goes negative. Para 17 page 85 of the paperwork, lordship, kindly have a glance. It is not a fact that the FIR has been prepared at my instance. PW 6 has not stated to me that the accused recovered the dead body and handed over to the police. Similarly, PW 7 has not stated to me that he gave recovery of the dead body from the spot. PW 8 has not stated that to me that the police took the dead body in an auto and took my signature. The I also not stated anything regarding how, from where and how he recovered the dead body.
What is the cause of death as per the doctor say? Who is the doctor?
Doctor is the examiner PW 11 LRC. Page 67 of the paperwork, lordship, and evidence.
Lacerated wound size 6 cm so and so depth over right frontal multiple bruises on internal dissection so and so. He was holding a tangia, na?
My lords.
That means the sharp side has not been used.
In this respect, your lordship, your lordship.
नहीं से आनी नहीं मैंने चुट्टो देनी से
The paragraph 3 of the cross examination of the IO lordship at page 84 to examine that part, lordship, the IO also negative. We have not sent for any examination, lordship. Para 384, lordship. I recovered the dead body from the Hallaguda Nala at 5 PM on 24/12. I made an inquest over the dead body at the spot. The body was not decomposed. The dead body was brought to outpost and then sent to hospital from spot for postmortem. I have not taken step to get the blood group of the accused and the deceased matched by a doctor. I have not sent the MO1 and 2 for examination of the fingerprints available on those weapons of offense. The weapon of the offense has stained with blood. There has been no examination to ascertain if the blood available on the weapon of the offense is blood of the deceased.
No. One thing is that if the last scene is believed, let us say, you with your pregnant wife, both of you went towards the jungle, and the time is 4 o'clock in the afternoon, right? And thereafter you alone returned at about 6 o'clock. That means 2 hours after. On the next day in that jungle, the dead body was found, and the cause of death is that head injury, which was a lacerated wound that is given. And apart from that, you recovered, and you have not explained anything as to when you parted with the company of your wife and where she went, how she died. So that is one of the main circumstances against you.
State Defense Counsel conducted the trial. Nowhere by suggested anything.
And you are remained in custody for
more than 12 years,
12
9
years,
months, 27 days, more or less, around 13 years.
Heard the land counsel for the petition, land counsel for the state. The land counsel for the petitioner submit that the petitioner is in judicial custody since 21, just a minute, 22/4/2012, and he was never released on bail during trial, and the petitioner is the husband of the deceased Namita Lima, and the occurrence in question took place 1 year after the marriage of 1 year after the marriage. The land counsel further submit that the case is based on circumstantial evidence, and the circumstance is the last scene of the petitioner in the company of the deceased and recovery of one tangia and stick at the instance of the petitioner, basing on the statement recorded under Section 27 of the Evidence Act. The land counsel submits that there are contradictions and in the evidence of the witnesses, and there are good chances of success in the case. Balance of convenience is in favor of the petitioner. Therefore, the bail application may be favorably considered. Land counsel for the state, on the other hand, oppose the prayer for bail and place the evidence of PW1, who is a witness to the last scene. Land counsel submits that the petitioner along with the deceased were last seen on 19/4/2012 at about 4 p.m. and the petitioner was holding a tangia, and he returned alone after 2 hours, which was seen also by PW1, and the dead body was found on the next day, and the doctor bracket PW11 who conducted post-mortem examination has seen a lacerated wound on the right frontal parietal region and opined that the cause of death was due to brain injury, and it was further found that the deceased was pregnant, and the uterus was containing a male child of 28 weeks. The land counsel submits that the London trial court has rightly found the appellant guilty, and it is not a fit case for grant of bail, considering the submission made by the land counsel for the respective parties, absence of any direct evidence, nature of circumstantial evidence appearing on record, the period of detention of the petitioner in judicial custody for more than 12.5 years, and absence of any chance of early hearing of the appeal, we are inclined to release the petitioner on bail allowed.
Obliged.
Item 7.
Mr. Sahu, where is your surrender certificate?
contact clerkship
No, Lenny na surrender. Sebi nine instruction 9. The Land Council for the appellant has not filed the surrender certificate as per order dated 29/7/2024. Let instruction be obtained from the Land and Trial Court as to whether the petitioner availed the interim bail order as per order dated 29/7/2024 in IA case number 1612 of 2019 or not, and if so, whether he surrendered at right time or not, and if not, what steps have been taken for the arrest of the petitioner. File be placed before registered judicial who shall do the needful. Yes.
Item 8.
Item 8, I am for the appellate number 1, madam. So kindly taken up after vacation.
After 8. Item 8.
8.
Item 8 is Kanti Kumar Burma.
My lord, this is
Pro bono.
on behalf of Mr. A.P. Bose, he is appointed as the pro bono, my lord.
The pro bono যাইছে এটা? It's a pro bono matter by Mr. Amit Bose.
No. I am 8, 9.
Upon 9.
9. What do you want?
My lord, we will file for the IA, my lord. On behalf of Mr. A.P. Bose, my lord, your lordship permitted me, will you? My say.
73 of 24.
My lord.
Okay, it's an application for bail. How many appellants are there?
Only one, my lord.
One. What is the date of custody?
10/4 to 19, my lord.
10/4?
9, my lord.
9.
2009. And what offense you have been found?
302, my lord.
302.
My lord.
Okay. You are never released on bail during
No, my
trial?
lord, in the trial as well.
Please come to paragraph number 2 of the judgment.
My lord. The fact giving rise to the prosecution case and within bread may be described herein under the undated 9/4/9 at about 5:45 p.m. While the deceased was engrossed in preparation of food, the accused coming in her front demanded the food, to which the deceased instructed him to wait till the completion of the preparation of the food.
How the deceased and the appellant are related?
Mother and son, my lord.
Okay. Deceased na kaun? Mother. Mother. कौन का पढ़ी जान
Completion of the preparation of food, but the accused being infuriated, brutally dealt a blow by means of a bamboo bahungi successfully on her forehead and over nasal portion, extending to the lower lip, causing profuse bleeding, which necessitated the son of the accused, who was by that time playing with his friend and little brother in front of the house of the proceed to the working place of this grandfather and apprised of the matter regarding the conduct of the accused compelled with the condition of the deceased, his grandmother. On receipt of the information, father of the accused, being followed by the co-workers, immediately rushed to the spot and found the deceased lying on the ground with full of blood.
There are eyewitnesses to the occurrence.
Yes, my lord.
Who are the eyewitnesses?
They're the 7, my lord. PW 7, my lord. Deposition number.
Who is the doctor conducted?
Doctor is a 9, my lord.
PW 9 and PW 7.
7 is the child witness, my lord.
PW 7 is a child witness.
No, my lord. Please, sorry. Yes, my lord. PW deposition of witness number 3 is the child witnesses.
No. We are asking you who are the eyewitnesses.
Eyewitnesses.
PW 3 or PW 7?
3.
3, not 7.
My lord.
Okay, and doctor
Page
is
49.
PW 9.
Yes, my lord.
Okay. What the doctor has seen, how the deceased died, fracture of the mandible, anterior face, next one, from.
As my lord, page 60, doctor, my lord. On dated 10/4/9.
And so on, so coma due to head injury. Head injury.
Yes, my lord.
And PW 3 is the Rastro.
Yes, my lord, 7 minutes.
कौन से को जी?
He is
Incident took place. Read it.
Yes, my lord.
Giving child witness of 7 years old son.
No, leave it. You come to the
Direct. The incident took place.
Incident took place in the event of the amount of 3 months back in in our house. At that time, my grandmother was prepared food. I was present in the house. My father came and assaulted by means of a bamboo bahungi on the head of my grandmother. Then my grandmother, out of fear, ran towards outside. Then my father, deceased, chased after her and again assaulted by means of a bamboo bahungi on her nose. Out of the assault, sustained bleeding injury. Out of the assault, she died at the spot. I have not been tortured by any person. Tutored by any person.
I have not been tutored by any person. May I?
I am deposing.
I am deposing what I have seen at the spot. The person who is standing in the dock is my father. He has committed assault on my grandmother. Though he is a child witness, he seems to be straightforward and without experiencing any conclusion while listening questions from the APP. He is also found weeping at the time of unfolding the facts.
This is demeanor.
So demeanor noted and child witness.
Yes.
Your son.
Yes.
Stated about
one son was playing outside. This son was inside the house. The dispute arose, my lord. The son of the deceased asked, demanded food. The food was not cooked. The mother said it would wait. And
the appellant asked for food.
Yes, appellant asked for. He is the son of the deceased.
Yes, that is there.
My lord, he asked for food. When the food mother
said he wait, then he assaulted.
It's not ready. That way he played up and this was the assault.
And informant is the father.
The informant is the father of the present appellant.
Are the learned counsel for the petitioner, learned counsel for the state. So we are proposing to grant bail when he was arguing. But since you are good, so.
My lord, I am doing pro bono. I even don't know, my lord, whether he is in which jail, my lord.
Custody since 10/4/2009 and further submits that the in view of the period of detention in judicial custody and nature of evidence available on record, the bail application may be favorably considered. In view of the stop, the land counsel for the state, on the other hand, opposed the prayer for bail and submitted that deceased is the mother of the petitioner, and when the petitioner asked for food and the mother asked him to wait for some time, the assault was made on the head by a bahungi, and PW3 is the eyewitness to the occurrence, who is none else than the son of the petitioner, was supported the prosecution case, and the doctor bracketed PW9 who conducted post-mortem examination has opined that the cause of death was due to shock and hemorrhage associated with coma due to head injury. Considering the submission made by the land counsel for the respective parties, nature of evidence available, period of detention of the petitioner in judicial custody for more than 15.5 years, and absence of any chance of early hearing of the case, we are inclined to release the petitioner on bail allowed.
May I pray one?
Yes.
Your Lordship may direct the registry to communicate because I do not
amount
from where he is.
20,000 to unsure karibe. The bail order be communicated by the Learned Registered Judicial to the Learned Trial Court, and the Learned Trial Court shall act upon it without awaiting for the certified copy of the bail order to be produced by the counsel for the.
So also to the superintendent. Superintendent.
So also a copy also be sent to the superintendent of jail. Jail dekhi debe se ko jail lo ache. Ko jail lo ache janchen di?
Rahul Kule.
That time he was in Raulkela.
When the JCL come.
When the JCL had come, he was in Raulkela.
Gratefully.
Obvious well.
Item 9.
May I please, Your Lordship? I have filed a IA for bail, my lord, so far as the petition number 3 and 5 is concerned, my lord.
IA number?
IA number 3258 of 24.
No, earlier who?
Yes, earlier all the appellant was moved for bail, my lord. So far as the 1, 3 and 5 are concerned, your lordship not inclined.
1, 3 and 5.
5 in order dated
Last rejected.
20th August 24.
28-24.
ପୁଣି କଣ ପଳେଇ ଆସିବ? କଣ ପୁଣି ଚେଞ୍ଜ ଇନ ସର୍କମଷ୍ଟାନ୍ସ ଦରକାର ନା? ଏବେ ରିଜେକ୍ଟ ହେଇଛି।
ସେ petition appellant number appellant number 3 is concerned is a 60 years.
ଟିକେ ଗ୍ୟାପ ଦେବେ ନା 28 ରେ ଆପଣଙ୍କର ରିଜେକ୍ଟ ହେଇଛି ସାଙ୍ଗେ ପଳେଇ
after vacation as
put of this matter after ensuing Xmas holiday. Yes, next.
Item 10.
May I please, Your Lordship? On the last occasion, Lordship called for the instruction in respect to interim application filed by the appellant number 6, Your Lordship.
कौन है जी कारण?
So on the ground the mother's health element, Your Lordship.
Mother's health.
Yes, Your Lordship.
कौन है जी मदन? What grounds you have stated? What ailment your mother is having?
She is suffering from cholelithiasis and crisis.
5 20-11-24 मैं 9 बार 20-11 ଟା ଅଛି 20-11 ଟା ଅଛି ପ୍ରପର ଅର୍ଡର
देखिए कौन से हाँ এটা তো genuine বলছি he has been treating the patient for gallbladder एक ये कौन है disease कौन ଦେଖିଥିଲେ Google रे सर्च
gallbladder stone ହେଇଛି
ଏଟା ଟିକେ ଦେଖିଲେ ଏଇ ଯୋଉ କଣ ସେ disease ଟା କଣ ସେଗୁଡା ନେଇଯା କପି କରି ନେଇଯା redness and swelling inflammation of the gallbladder ଯେତେବେଳେ ଗୋଟେ ଡିଜିଜ ଟା ହେଲା ଆପଣ ଡାକ୍ତର ସାର୍ଟିଫିକେଟ ଟା ଦେଇଛନ୍ତି ଆପଣ କିଛି ଗୋଟେ ଆସିଲାନି ଆଗ୍ରହ ଯେ ଏଟା ଡିଜିଜ ଟା କଣ ଦେଇଛି କାଳେ ପଚାରିଦେବେ ମତେ ଡିଜିଜ
regarding kidney
ନା ନା ଏଟା gallbladder କୁହାଯାଇଛି
gallbladder ଏଟା ତ ଏଗୁଡାକ ସବୁ ରହିବା କଥା ମିନିମମ ଜିନିଷ ଗୋଟେ ଡିଜିଜ ପାଇଁ ଆପଣ ମା ସଫର କରୁଛନ୍ତି ବୋଲି ଆର ପିଟିସନ ଟା ଫାଇଲ କରୁଛନ୍ତି ସେ ଡିଜିଜ ଟା କଣଟା ଏଟା ପଢିବା ଦରକାର ନାହିଁ ଆଜିକାଲି ଗୁଗୁଲ ରେ ହେଇଗଲା ମାର୍କେଟ ପଟିଂ ପଳେଇ ଆସୁଛି
even your medical prescription was that gallbladder is distended receive gas in C
or the land counsel for the petition land counsel for the state this interim application has been filed for interim bail of appellant number 6 the name कौन कौन
Rintu alias Ranjan Machi.
Rintu alias Ranjan Machi for grant of interim bail on the ground of the ailment of the mother who has been stated to have been diagnosed suffering from so and so it likes paragraph number 4 on the last date the land council for the state was asked to obtain instruction regarding the authenticity of the medical documents annexed to the interim application. The land council for the state has produced the report of the IIC town police station Baleswar dated 13/12/2024 which indicates that an inquiry has been conducted and the treating physician has confirmed that the prescription issued in favor of the mother of the petitioner are genuine, and he has been treating the patient for gallbladder disease. The report is taken on record. Considering the submission made by the learned counsel for the respective parties, the government's taken in the interim application, the medical document annexed to the application, and the report furnished by the IIC so and so. We are inclined to release the petitioner for a period of 1 month from the date of release. Matter be listed on such and such date. The land counsel for the appellant shall file the surrender certificate of appellant number 6. Hello? Yes.
Item 11.
Now, this is the case where 5 persons have been raised. For last 2 occasions, I am moving bail for the 2 main accused persons. That is criminal appeal number 479 of 24. Again?
What number?
479 of 24.
79. Angara Maji.
Angara Maji, here both the
information which he has received as per order dated so and so is not satisfactory. Okay.
information ମଗାଇଥିଲା ଯେ ଏମାନେ ଦି ଜଣ husband and wife both are inside custody or not, and there are minor child of these two.
Your submission was that the petitioners are 2 ladies.
Again.
Their husbands are on jail custody.
Again.
And the petitioners were on bail during trial. They have small children in their house, and so criminal antecedent number 1, family status, तापरे custody certificate ए सब जिनस जे तू आज कोन से विषय कोन आनिले सब report.
So far criminal antecedent is concerned, Ungara Maji, Prem Thapa, against Prem Thapa, there is criminal antecedent. Hamu dekhi douchi. Bharat Thapa, Joy Krishna Thapa have criminal antecedent. And the present petitioner have no criminal antecedent.
Ungara Maji nare or Ponko Jini Maji nare kichi criminal antecedent nai. Okay, then.
So far custody is concerned, Ungara Maji, all total 466 days. 17/9/2024
What about number 2?
Pankajini Maji, 440 days.
What about the other things?
My lord, the eyewitness are there, my lord.
No. The
husband man
छुआ कौन थिले ता पिला पिली
ते रिपोर्ट आसिनी
कौन सेति पय आपण अधा केमति आउथि जरा पर पिला पिली से कहलेन ता ग्राउंड होउछि जे घरे छोटो छुआ गुडा अछंती आउ कि नाहति ता स्वामी स्त्री दी जन जाको जेल ले अछंती.
That report what
the submission lekha है जे order रे. There are small children in the house, and so you are to
next week aso mu
family status upare madhya kuaitla aniya pa.
My lord, next week aso mu yes.
Next week kono
the learned counsel for the petitioner, learned counsel for the state submits that he has received the instruction card.
Instruction from the IAC, Sadar Police Station, Balangir.
Sadar Police Station, Balangir, that both the petitioners, it is known as 479, that both the lady appellants have no criminal antecedent. And the as per the dated Kevin.
17/9/2024 custody certificate.
As per the custody certificate dated 17/9/2024, the appellant number 1, namely so and so, is in judicial custody for 466 days, and appellant number so and so is in judicial custody for 440 days. However, he has not received the instructions so far as family status of the petitioner, so also whether they have any children or not, and the matter may be and some further time may be granted. So put up this matter, give a date along with assurance on the matter.
My lord,
Yes,
I am
ma'am.
appearing for the CRLA 384.
Ah.
In that 384,
Yes.
my lord, in that 5 ladies are there, and I have stated that petition number 4 is 100% blind.
ତା ଦେହରେ ଟିକେ 384 କିଛି ଅର୍ଡର ହେଇଥିଲା?
ହଁ my lord, ହେଇଥିଲା ତାକୁ ମଗା ବି ହେଇଥିଲା।
Wait. ହଁ ତା ଦେହରେ କଣ ଆଣିଲେ ଆପଣ? ଏଇ ଯୋଉ ଆଇଟମ ନମ୍ବର 384 ରେ order ହେଇଥିଲା, the order reads like this: Learned counsel for the petitioner submit that the petitioners are ladies. Petition number 1 is aged about 69 years. 4 is a blind lady, and you are supposed to obtain instruction about the health condition of so and so. Petition number 4 କଣ ଆଣିଲେ?
କଷ୍ଟଡି ସାର୍ଟିଫିକେଟ ଆସିଛି।
କେତେ ଦିନ କହିଯାନ୍ତୁ ଲେଖିଦେବା।
ଡିଜେବଲ୍ ସାର୍ଟିଫିକେଟ ମଧ୍ୟ ଆସିଛି।
এটা CRL number 384 of 2024 example. The learned counsel for the state submits that he has received the custody certificate which indicates এটা जो file କରିଛନ୍ତି ये जो bail application for all the
all five ladies.
କେତେ କେବେ ଆସିଛି କେତେ ଦିନ?
କିଆ ଫୁଲ ମାଝି 423 days.
That is appellant number 1.
423 days.
Yes.
Bhagavati Machi.
Number 2.
472 days.
3.
Nila Machi. 423 days. Indu Machi. 423 days. Soibani 423 days. And disability certificate of Indu Machi 100%
blind.
ନା ତା ପରେ ବ୍ଲାଇଣ୍ଡ ହେଇଛି।
ଆଚ୍ଛା ଏଇ ଯୋଉ କଷ୍ଟଡି ସାର୍ଟିଫିକେଟ ଡେଟ୍
ବ୍ଲାଇଣ୍ଡ ସାର୍ଟିଫିକେଟଟା କଷ୍ଟଡି ସାର୍ଟିଫିକେଟ 21/9/2024
21/9/2024। ଆଚ୍ଛା ଏଟା ଲେଖି ଦିଅନ୍ତୁ। Learned counsel for the that is in item number that is 384 384 of 2024. Learned counsel for the state has received the custody certificate from the concerned jail superintendent which indicates that except appellant number 2 all other appellants are in judicial custody for 423 days. So far as appellant number 2 is concerned, he is in custody, she is in custody for 472 days. As per the custody certificate dated for the 21/9/2024. The land council submits that the report also indicates that the appellant number 4, namely Srimati Indu Maji, is 100% blind. बाकी अपन को कुहाइथला
69 years.
CA नहीं
किसी नहीं। She further submit that there is no criminal antecedent against any of the appellants. So it is to be listed along with that. So get prepared on that day if it not will hear on merit. 516 कौन है इसका? आनिचन इधर दे।
कोडारा
516 प्रेम थापा
कोई जन लेखा गले एकाथरे कोनानी
मतलब टिके ब्रेक करथले से 100% ब्लाइंड टक टिके
नहीं से ये सब आसीबो से सेकंड वीक रे सब आसीबो वी कंसीडर
प्रेम थापानार क्रिमिनल एंटीसीडेंट अछि।
अच्छा एई केसटा छडा आउ केटा केस अछि?
आ गोटे केस अछि बलांगीर पीएस केस नंबर 38/2012
offense
143 145 149 283 341 IPC।
अपन इंस्ट्रक्शन नियो तापरे। अच्छा लर्न काउंसिल फॉर द এটা লিখি হচ্ছেন CRL number 516 of 2024 last item. The Learning Council for the State on Instruction submitted that the appellant Prem Thappa has one criminal antecedent which is of the year 2012. 12. Let the Learning Council for the appellant obtain instruction about the status of such case.
Custody 3,708.
And file a comprehensive affidavit. He further submits that as per the custody certificate
Dated 17/9/2024.
17/9/2024, the appellant is in judicial custody for
3,708 days.
3,708
days.
8 days. Yes. Second week of January. Yes, next item.
ଅଧ ଲେଡିଟା ବି ଯାଇକି ମର୍ଡର କେସ୍ କରିଦେଲା।
ଏବେ ଅନ୍ଧ ହେଇଯାଇଛି ନା ଆଉ।
Next is
10 ବର୍ଷ ପୂର୍ବରୁ।
Item 12.
Item
May
ଏମାନେ କେହି ନାହିଁ।
I'm appearing version mode, Your Lordship. Item number 12.
Yes, madam.
Yes, Your Lordship, in the present case, the appellant has been languishing in such custody since 14/7/2017. Lordship, he has been convicted under section 302 IPC, read with section.
Madam, date ta kebe pehle custody tha?
Your Lordship, 14/7/2017.
14/7/2000. Okay, and offense under which you have been found guilty is
302 IPC, read with section 3 and 9B of Explosive Substance Act.
Okay, you have got the information about the criminal antecedent. The order was passed. Deposition copy supplied. Any criminal antecedent?
Asking.
No, he has been found guilty. Why we are asking for the criminal antecedent? Since Explosives Act are there, Explosive Substances Act there. That is why we are asking you to obtain the criminal antecedent if any.
ହେଇଥାଉ ଆଣନ୍ତୁ
ହେଇଥାଇପାରେ
ଆସିଛି ରିପୋର୍ଟ ଅଛି ଆଉ ତାହେଲେ ରିପୋର୍ଟ ଆଣନ୍ତୁ habitual
this submission whether he has remained in custody for more than 7 years as is stated. 14/7/2017 custody certificate भी आनो है देखो IN number so this is an application for bail. Learning Council for the petitioner submits that the petitioner is in judicial custody since 14/7/2017. Learned Council for the state, on the other hand, submits that he may be given some time to produce the custody certificate, so also to obtain instruction about the criminal antecedent, if any, against the petitioner. Put up this matter. Second week,
Oh, bless you.
Yeah.
Item 13.
May I be your lordship? Offense.
I